We don't need to listen to those detailed rape fantasies. Okay. Oral arguments are important for Supreme Court cases because based on the questions that are being asked by the Supreme Court justices, you can kind of tell the direction that they're probably leaning when it comes to the particular case. And then it also gives the litigants chances to, would you call them litigants for Supreme Court cases? You would, right? To flesh out their ideas and opinions a bit more. And then based on the questions asked here, and then based on what the Supreme Court justices write and their opinions to the case, it just fleshes out kind of the understanding and the I guess the legal perspectives of the justices when they're making their rulings. What's your opinion of the event going into this? I do not know enough about the case to say. I don't have a strong opinion on any of this. TikTok Inc. v. Garland. Was reminded of this video when you're looking into Seattle versus Vancouver and trying to find data. Do cities subsidize rural lifestyles? Okay. Are you associating with modern day debates anymore? I mean, if we can find events to do things with, yeah. I'm not like not associating with them, right? It's not like a thing like that. I just haven't, there haven't been any things that have like piqued my interest lately for. Okay, so just to understand, I guess, a little bit about this, see if I can understand how we make this, what's going on here. Okay, so we have on December 16th, 2024, an application for an injunction pending review submitted to the Chief Justice. An injunction, I believe legally, is when you're asking a court to take an action before a case has finished. And then whether or not that's granted depends upon, on a judge's like first glance, like whether or not he thinks you're likely to succeed on the merits of the case or not. I don't know if injunction means anything different here. If it's like in a Supreme Court context, I don't think it does, right? I don't know what the injunction asks for. The DC Circuit's opinion and judgment denying petitions for review entered December 6, 2024. Anytime you talk about a federal court, there's going to be a statement saying that it's either a federal court or it'll be a district court or like a circuit court. It'll be something like that. So when you hear something that's called like the Southern District of New York, that's a federal court. Or like a, well, I shouldn't always say circuit court, actually. That's not necessarily true. No, wait. I think circuit court always is like your first, second, third, up to 11th or 13th circuit or whatever. And that the circuit court is always going to be your first federal court of appeals. And then your Supreme Court is your final court of appeals, basically, right? So you have your federal court is your first start, and then your circuit courts are your circuit court of appeals, and then your Supreme Court is the final one here. And actually, I'm sorry, when I talked about an injunction, what I actually was just referring to was a preliminary injunction. An injunction doesn't necessarily have to come before the court's ruling, I guess. That's not correct what I said earlier. Let me just triple check on this. Injunction, what, Westlaw, is this the site? An injunction is an equitable remedy in which a court orders a party to perform or refrain from performing a particular act. A prohibitory injunction is an order forbidding a party from performing an act. A mandatory injunction is an order to perform an act. An injunction may be temporary, in place until judgment is entered, called a preliminary injunction in the US, and an interim injunction in the UK, or permanent, continuing after the conclusion of proceedings, either perpetually or until a specified date, a final injunction. Courts usually grant injunctions as final remedies only where the applicant demonstrates that its legal right has been infringed or is about to be infringed and money damages are inadequate compensation. An injunction needs to be in clear terms so that a party can understand what it must or must not do. If a party violates the terms of an injunction, it may be held in contempt of court. Oh, okay. Let me just read through some of this so I can understand 100% what the case is actually about. Okay. Corporate disclosure statement, parties to the proceedings and related proceedings. Applicants who were petitioners in the lead case in the DC Circuit, TikTok, are TikTok Inc. and ByteDance. Okay. Respondents who are respondents. Okay. This is it's TikTok Inc. and ByteDance versus Merrick B. Garland in his official capacity as Attorney General of the United States. Okay. The Honorable John G. Roberts, Jr., Chief Justice of the United States and Circuit Justice for the D.C. Circuit. Pursuant to Rule 22 of the Court and 28 U.S.C. 1651, applicants TikTok Inc. and ByteDance Ltd. What does that stand for? Limited company? I don't even remember. Respectfully request an injunction against enforcement of the Protecting Americans from Foreign Adversary Controlled Applications Act, published L number blah, blah, blah. Okay. Pursuant to Rule 22 of this court. So these are going to be, when somebody just says a rule, I think that always refers to like civil rules of procedure, I believe. I think, maybe, hold on. Rule 22, or I shouldn't have said that actually. Maybe these are just like rules of the Supreme Court, I should say. Okay, I guess. Okay. Wait, okay. Okay, Rule 22, applications to individual justices. An application addressed to an individual justice shall be filed with the clerk, who will transmit it promptly to the justice concerned. If an individual justice has authority to grant the sought relief, the original and 2 copies of any application addressed to an individual shall be prepared as required by Rule 33.2. Addressed to justice allotted in the circuit. Okay, an application addressed to an individual justice. Okay. So I think this is just how you, I guess like the process by which you appeal to a justice to take a case or whatever, basically. Respectfully request an injunction against enforcement of the Protecting Americans from Foreign Adversary Controlled Applications Act. Okay, so this is a law that was passed by Congress that would have, I'm guessing, forced Merrick Garland to ban TikTok, basically. Has this passed already? Wait, what is this 28 USC? USC should always refer to the US code. So this is going to be codified law. The Supreme Court and all courts established by acts of Congress may issue all writs necessary or appropriate in aid of the respective jurisdictions and agreeable to use. Okay, so this is just how they basically do it. Your process for appealing to the Supreme Court, basically. Okay. Protecting Americans from Foreign Adversary Controlled Applications Act. Committee sponsors, committee meetings. Oh, sorry, I didn't know I could scroll down. Okay, summary. Text. How long is this bill? Oh, wait, that's actually not bad. Sorry. That's bad enough. Fuck that. Sheesh. This bill prohibits distributing, maintaining, or providing internet hosting services. Wait. One second, fuck. I had a 200-word essay due tomorrow. Sorry. Okay. This bill prohibits distributing, maintaining, or providing internet hosting services for a foreign adversary controlled application. However, the prohibition does not apply to a covered application that executes a qualified divestiture as determined by the president. Under the bill, a foreign adversary controlled application is directly or indirectly operated by ByteDance Ltd. Or TikTok. Wait, what does Ltd stand for? I'm sorry, I keep fucking this up. Limited liability. Cringe. Okay. Okay. Or TikTok, including subsidiaries or successors that are controlled by a foreign adversary, or 2, a social media company that is controlled by a foreign adversary and has been determined by the president to present a significant threat to national security. The prohibition does not apply to an application that is primarily used to post product reviews, business reviews, or travel information and reviews. The bill authorizes the Department of Justice to investigate violations of the bill and enforce the bill's provisions. Entities that violate the bill are subject to civil penalties based on the number of users. The bill requires a covered application to provide a user with all available account data, including posts, photos, and videos, at the user's request before the prohibition takes effect. User all available account. Okay. The bill gives the U.S. Court of Appeals for the District of Columbia exclusive jurisdiction over any challenge to the bill. Further, a challenge to the bill must be brought within 165 days after the bill's enactment date. A challenge to any action, finding, or determination under the bill must be brought within 90 days of the action, finding, or determination. I don't know if I want to get like super into the actual wordings of the bill, but the interesting part I think is I wonder if there's text within the bill that defines what is a foreign adversary. If we have a definition of that, I'm curious. And then what does it mean when a social media company is controlled by a foreign adversary? Like, let's say that ByteDance buys a 20% equity stake in my company. Does the president have the ability to say that? Because here it gives the president the ability to determine if any company that is controlled by a foreign adversary presents a significant threat to national security. I'm also curious, what is the maximum civil penalty for stuff like this? Is it just inordinate amounts of cash, or can they like shut you down, or we can just, I guess, check real quick. It also gives an escape clause, and it seems like this escape is solely at the discretion of the president, which is a little bit scary, I think, but because you have, hold on. The prohibition does not apply to a covered application that executes a qualified divestiture as determined by the president. So the president of the United States seems to have the legal ability to exclude somebody or say that somebody is within good faith. I shouldn't be using those types of words. That this wouldn't apply to them, basically. That they have done something that qualifies as a divestiture, and so you're no longer subject to the civil penalties that are outlined in this bill. Surely that just means the executive branch. Well, it depends on who Congress authorized to make the act, but it'll say here in the specific text of the bill. And actually, it's not that long, so we can check real quick. Okay, it shall be unlawful for an entity to distribute, maintain, or update, or enable the distribution, maintenance, or updating of a foreign adversary-controlled application by carrying out within the land or maritime borders of the U.S. any of the following. So you can't provide services to distribute, maintain, or update such foreign adversary-controlled application, including any source code of such application by means of a marketplace, including online mobile application store through which users within the land and maritime borders of the U.S. may access, maintain, or update such application. So I believe this would also make like this would also apply to like the Apple Store or the Google Store or whatever as well, right? This would also apply to anybody because you would be distributing. It would also probably prohibit you from working on these things as well too, right? Like TikTok and all these companies, if they hired you, because then you'd be maintaining and updating these things as well. So this would target like everybody associated with this thing, I think. Providing internet hosting services to enable the distribution, maintenance, or updating of such foreign adversary control applications for you. Okay, yeah, this is like basically covering everybody, yeah. Applicability in the case of an application that satisfies the definition of a foreign adversary controlled application pursuant to subsection G3A, beginning on the date that is 180 days after the date of the enactment of this act, and B, in the case of an application, okay, I don't know. Satisfies the definition of foreign adversary controlled okay. So this is who it applies to. It's telling you that the act is going to take 180 days to come into effect, basically. Okay, and then these are who it applies to. Let's see. Before the date on which a prohibition under subsection A applies before an adversary control application, the entity that owns or controls such application shall provide, upon request by a user of such application within the land of maritime borders of the U.S., to such user all the available data related to the account of such user with respect to such application. Such data shall be provided in a machine-readable format and shall include any data maintained by such application with respect to the account of such user, including content and all other account information. I don't know why this is in here. I don't know if somebody knows. This sounds like just like one of the basically the GDPR provisions. Are we just like copying that and we just have this in here? Data and information portability to alternative applications. Oh, maybe this is to give Americans an easy way to jump from one application to another. Because an American might think like, oh no, all of my videos and pictures of my dead children are on TikTok and now I'm going to lose them all. And this is saying, well, you have to provide this, I guess, in an easily downloadable format to people using whatever, TikTok in this case, right? Destiny, find your streams as completely for politics. I grew up insanely conservative and thought that nobody else really had my experience. I really appreciate what you do. Thank you. Well, thanks, buddy. Exemptions. So exemptions for qualified divestitures. This doesn't apply to a foreign adversary controlled application with respect to which a qualified divestiture is executed before the date on which a prohibition under subsection A would begin to apply to such applications, and it shall cease to apply in the case of a foreign adversary controlled application with respect to which a qualified divestiture is executed after the date on which a prohibition under subsection A applies to such. What if you do it exactly on the date? Just kidding. Okay, exemptions for certain necessary services subject to A and B do not apply to services provided with respect to a foreign adversary control application that are necessary for an entity to attain compliance with such subsections. Okay. This sounds like, so if you're at TikTok and you have to hire a company to make you compliant, then, or if you're a company that helps other companies become compliant with this bill, you're not going to get sued for it, which is, that makes sense. It's probably an acceptable carve out, right? Okay, enforcement. These are the civil penalties that will happen if you do this bad stuff. Foreign adversary control application violations. Any that violates subsection A shall be subject to pay a civil penalty in an amount not to exceed the amount that results from multiplying $5,000 by the number of users within the land or maritime borders of the United States to have accessed, maintained, or updated a foreign adversary control application as a result of such violation. So, how many TikTok users in the USA? 170 million people. Is that even that much of a, well, it's probably, you probably do this like every month or year or something, right? It's 170 million people, which would be, oh, I'm sorry, hold on, $5,000 each. I was thinking like $5 or $50 each. Wait, that's an insane amount of money. Sorry. Because 150 million times 5 is 500 plus 350 is 850 million. So 50 would be 8.5 billion. 500 would be 85 billion. $5,000 would be 850 billion. So there'd be an $850 billion civil penalty, which is it's a big guy. An entity that violates subsection B shall be subject to pay a civil penalty. The amount not exceed this. Okay, action by Attorney General. Okay, the Attorney General shall conduct investigations related to potential violations of subsections A or B, and if such an investigation results in a determination that a violation has occurred, the AG shall pursue enforcement under paragraph 1 and may bring an action in an appropriate district court of the United States for appropriate relief, including civil penalties under paragraph 1 or declaratory and injunctive relief. Severability in general of any provision of the section or the application of the section to any person or circumstance is held invalid. The invalidity shall not affect the other provisions or applications of this section that can be given effect without the invalid provision or application. If the application of any provision of this section is held invalid with respect to a foreign adversary controlled application that satisfies the definition of such term pursuant to subsections 3GA, such invalidity shall not affect or preclude the application of the same provision of this section to such foreign adversary controlled application by means of a subsequent determination pursuant to subsection G3B. Nothing in this act may be construed to authorize the AG to pursue enforcement under this section other than enforcement of subsection A or B, or to authorize the AG to pursue enforcement under the section against an individual user of a foreign adversary controlled application, or, except as expressly provided herein, to alter or affect any other authority provided by or established under another provision of federal law. Definitions. Okay. Okay. So we have a definition section. That's good. So controlled by a foreign adversary. The term controlled by a foreign adversary means with respect to a covered company or other entity that such a company or other entity is a foreign person that is domiciled in or is headquartered in, has its principal place of business in, or is organized under the laws of a foreign adversary country, entity, or an entity with respect to which a foreign person or combination of foreign persons described in subparagraph A directly or indirectly owns at least a 20% stake, or a person subject to the direction or control of a foreign person or entity described in subparagraph A or B. And then a covered company in general, the term, this is a little bit interesting because this might create a civil cause of action for other things that we wouldn't find as related. So like that Tenet Media stuff, that was a company that existed in the United States of America. I wonder if this would create a private cause of action for the federal government to also sue under this law. You can't do it like retroactively, but to sue like some shit like that if money was flowing in and you weren't supposed to be. It would also create like civil penalties under this, I think. Covered company in general, the term covered company means an entity that operates directly or indirectly, including through a parent company, subsidiary, or affiliate, a website, desktop application, mobile application, or augmented or immersive technology. It's good to read through stuff like this also. We're reading it through because we should read it through, okay? It's good to read through stuff like this also because, like, I guarantee you there are going to be debates coming up where people are going to say retarded shit like, well, what if it's like 5 different foreign actors in different company or in different countries? Like, generally they're going to be carve-outs or stuff like this, or it's going to include it. Or like, well, what if it's just a parent company that owns it and the real company is in China? It's like, yeah, generally this is covered in law. It's not like they're not retards, usually. So it's always good to have this too. Okay. Permits a user to create an account or profile to generate, share, and view text, images, videos, or real-time communications or similar content. Has more than 1 million monthly active users with respect to at least 2 of the 3 months preceding the date. Oh, wait. The term covered means an entity that operates. Oh, wait. Okay. So this would exclude like the Tenet Media thing, I think. Okay. And 3, enables 1 or more users to generate or distribute content that can be viewed by other users of the website, desktop application, mobile application, or augmented or immersive technology application, and enable, okay. Jesus, this is like razor targeting fucking TikTok. Is there any other company right now that anybody's talked about that this would even apply to? Or would this literally only be TikTok? Exclusion. The term covered company does not include an entity that operates a website, desktop application, mobile application, or augmented or immersive technology application whose primary purpose to allow users to post product reviews, business reviews, or travel information and reviews. Foreign adversary control application. The term foreign adversary control application means a website, desktop application, that is any of ByteDance, TikTok, a subsidiary or a successor to an entity identified in clause 1 or 2 that's controlled by a foreign adversary, or an entity owned or controlled directly or indirectly by an entity identified in clauses 1, 2, or 3. Or B, a company that is controlled by a foreign adversary and that is determined by the president to present a significant threat to the national security of the United States following the issuance of a public notice proposing such determination and a public report to Congress submitted not less than 30 days before such determination describing the specific national security concerns involved and containing a classified annex and a description of what assets would need to be divested to execute a qualified divestiture. So he has to make a public report to Congress about this, but it doesn't sound like he needs approval from Congress. He just has to report to them about it, and then he can describe what he feels the company needs to do in order to escape the civil penalties outlined here, to not be a qualified entity or whatever anymore, which is what the divestiture would be. And then foreign adversary country. The term foreign adversary country means a country specified in section 4872, subsection D2 of Title 10, the U.S. Code. Okay, so we can look at this to figure out exactly what a foreign adversary country is. So you can see here, like the U.S. Code we go to here, acquisition of sensitive materials from non-allied foreign nations prohibitions. So this is going to give us a definition for foreign adversary country, and it's in subsection D2. So we're going to scroll down to D. And then subsection 2, covered nations. The term covered nation means the Democratic People's Republic of North Korea, the People's Republic of China, the Russian Federation, and the Islamic Republic of Iran. Okay. So it's just, so I don't know if this code gets updated by Congress. I guess when they want to add, does Congress have to pass a new law then? This is like hard coding instead of using a, whatever. Is this so you have to pass a law if you want to change this list, I'm guessing? I'm guessing. Okay. Internet hosting service means a service through which storage and computing resources are provided by or to an individual organization for the accommodation and maintenance of one or more websites. Okay, qualified divestiture. Okay, the term qualified divestiture. So this is important because this is how your company escapes. This is how your company escapes this law, basically. The term qualified divestiture means a divestiture or similar transaction that the president determines through an interagency process would result in the relevant foreign adversary controlled application no longer being controlled by a foreign adversary, and B, the president determines through an interagency process precludes the establishment or maintenance of any operational relationship between the U.S. operations of the relevant foreign adversary controlled application and any formerly affiliated entities that are controlled by a foreign adversary, including any cooperation with respect to the operation of a content recommendation algorithm or an agreement with respect to data sharing. And then source code. The term source code means the combination of text and other characters comprising the content, both viewable and non-viewable, of a software application, including any publishing language, programming language, protocol, or functional content, as well as any successor languages or protocols. The term United States includes the territories of the U.S. Okay. And then final section, judicial review. A right of action. A petition for review challenging the act or any action, finding or determination under this act may be filed only in the U.S. Court of Appeals for the District of Columbia Circuit. And then exclusive jurisdiction. The U.S. Court of Appeals for the District of Columbia Circuit shall have exclusive jurisdiction over any challenge to this act or any action, finding, or determination under this act. So this means that you couldn't go to like the 9th Circuit or the 11th Circuit or whatever. You have to do it in the DC Circuit, I guess, for the Court of Appeals for this. And then the statute of limitations, a challenge may only be brought in the case of a challenge to this act not later than 165 days after the date of the enactment of this act, and in the case of a challenge to any action, finding, or determination under this act not later than 90 days after the date of such action, finding, or determination. Okay. Why is the legislature allowed to decide where the court hears it? I don't really know, actually. I'm not sure where that right comes from. Sorry, okay. like intuitively that feels improper to me, but I mean, I imagine there's a reason why they're allowed. Choice of venue is civil procedure. FRCP. I'm guessing that means Federal Rules of Civil Procedure. Except as otherwise provided by law, the section shall govern the venue of all civil actions brought in district courts of the United States, and the proper venue for civil action be determined without regard to whether the action is local or transitory in nature. Okay. If something bad is going to happen either way, is it unethical to profit from it? For example, owning stocks that will profit from immigrant deportations, from stocks like Geo, CXW, et cetera. I don't know. That's it. You're getting a lot removed from the action of this sort of thing. Okay. All right. Sorry. So back to this. Okay. So we've read the law. Wait. What the fuck is this? Okay. Okay. So pretty short, pretty simple bill. The law. Okay. So they have, your first choice is not the Supreme Court. So this must have already been filed in the DC Circuit. And then this is where now it's going up to the Supreme Court. The people who are going to be suing in this case is going to be TikTok, and then TikTok and the parties associated with TikTok, because I imagine that they're going to want to challenge. I don't know why. I guess you can't sue a law, and I guess they wouldn't sue Congress. They're suing the person that takes the action against them, because that's who they would have standing to take action against. So in this case, Merrick Garland is being called out as the defendant in this, because in the law that we read, it's the Attorney General, who's the head of the Department of Justice, who's the one taking legal action against them, or at least, or civil action, I guess, or whatever, by imposing some penalties. So they're suing him in order to get an injunction, basically saying you can't do this, I guess, because it's unconstitutional, I guess, whatever they're going to argue in here. And so Merrick Garland would be the defendant in this case. But it's not like, it wouldn't be Merrick Garland. Oh, they even say it here, yeah. It's not like Merrick Garland, the individual, is being sued. It's Merrick Garland in his official capacity as Attorney General of the United States. All right. Okay, so applicants who are petitioners in the lead case in the DC Circuit are TikTok and ByteDance Ltd. pursuant to Rule 20 laws, wholly subsidiary. Okay. Respondent, who is respondent in the DC Circuit, is Merrick B. Garland, is official capacity as AG in the United States. Okay. So the DC Circuit's opinion and judgment denying petitions for review entered December 6, 2024. The DC Circuit's order denying injunction pending Supreme Court review entered December 13th. Okay. A parallel challenge remains pending in the DC Circuit. Kennedy v. Garland. I don't know what Kennedy is. Is that another? Who is this? Robert Kennedy. That one. What is this case about? Is he trying to save TikTok or something? Okay, I don't know. Any Trump-related lawsuits or anything on that is always like kangaroo court shit. These guys are fucking retarded. So I don't know. Maybe that one isn't. I don't know. But generally, don't waste your time reading anything having to do with any of like Trump legal counsel doing court cases, because it's literally fucking retards. Okay. Destiny. Court jurisdiction stripping is a constitutional right for Congress from the Constitution. Article 3, Section 1. Oh, or Article 3, Section 2. Article 3, Section 2. Sorry, we'll just read this. Why not? The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizen of another state, between citizens of different states, between citizens of the same state claiming lands that are different, or under granted different lands, between wait, fuck. Article 3, Section 2. In all cases affecting ambassadors, those which shall be, the Supreme Court shall have original, in all cases before mentioned, the Supreme Court shall, both those. Oh, okay. It's probably coming from clause 2 here, sorry. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Okay, so this is the part. Okay, cool. All right. Okay. Boom, 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 boom. All right, reading through this bullshit. To the Honorable Judge, okay, I don't think we'll read this whole thing, but okay, so they are requesting an injunction against enforcement of the Protecting Americans from Foreign Adversary Controlled Applications Act, pending this court's review of the D.C. Circuit's judgment upholding the act. Applicants sought this interim relief from the D.C. Circuit, which had exclusive original jurisdiction, but it denied relief. So the D.C. Circuit shot them down, saying that this act is fine, and now they're going to the Supreme Court. Okay. Introduction. This is just going to be them laying out like the factual case, and slanted in their favor. None of it's going to be false, but or slightly opinionated, right? I think the introduction is where you'll write things like that's where Finkelstein is like Norman Finkelstein, known worldwide as a famous speaker, and blah blah blah. So Congress has enacted a massive and unprecedented speech restriction. TikTok is an online platform that is one of the nation's most popular and important venues for communication. There's a strong public interest that the court have the opportunity to exercise plenary review. This case raises novel constitutional questions of profound significance to the entire nation, and this court is the only forum for appellate review under the act. An interim injunction is also appropriate because it will give the incoming administration time to determine its position, as the president-elect and his advisors have voiced support for saving TikTok. An injunction will not materially harm the government. There is no imminent threat to national security. This is particularly clear since, one, Congress itself delayed the act's effective date for 270, potentially 360 days. The government's own defense of the act asserts only that China could engage in certain harmful conduct through TikTok. Not that there's any evidence of it. A modest delay in enforcing the act will create breathing room for this court to conduct an orderly review and the new administration to evaluate the matter. Especially given this lopsided equitable balance, the prospect that this court will grant certiorari and reverse is sufficiently high. Grant certiorari is just like a fancy way of saying the court agrees to hear the case, and reverse is sufficiently high to warrant the brief pause needed to create time for further deliberation. So obviously TikTok is going to ask for some sort of preliminary injunction where they're saying, hey, while this case is being decided, can we like hold off on any penalties from the government, because it's going to fuck us. It'll cause irreparable harm, right? And then if we win the case, it doesn't even matter if we win the case. We've been so harmed by the actions of the defendant here. We've been so harmed by the people that we're suing that it doesn't even matter if we win. Now the court can't even give us the relief we need from the injury we're claiming to suffer. So we need a preliminary injunction to prevent them from harming us. And look, if you grant the injunction, it's not like we're going to hurt them, right? That's the argument being made here. The D.C. Circuit's holding that this unprecedented law satisfies strict scrutiny is indisputably worthy. So your levels of review, when you're talking about a law that's being passed, if a state passes a law that basically says something like the stoplights are going to be turned off and you're going to use stop signs instead on like weekends, that's a law that doesn't like implicate some fundamental right or like gender or anything like that, the review that you would have to know if that law is okay would be like a rational basis review. You're just asking like, is there any reason why the state might pass this, like any reason for public safety? And as long as the state can basically give any answer whatsoever, it's like 99% of the time the state's going to win. You've got intermediate scrutiny that implicates, I think, certain classes. So like if you're making a law about maybe like race or gender or something, like women's only gyms can be protected or something like that, then now the state has to provide like, I don't know what the legal words are, but they have to provide like a better argument, a pretty strong argument. Like the default is that you can't do this. You need to overcome some burden because you have to prove because you're being sexist or racist or something. There are different classes or rights that are usually implicated for each of these two categories. I don't know for the last two. And then the strict scrutiny is basically saying that you are you're implicating some like fundamental right. This is like a really big deal. Like you have a law that is like really, really restrictive to something that we expect is like a really important fundamental right. Like you're restricting like a freedom of speech, or you're making something that's like crazy. Like we'd assume, I'm not using good legal term. Wait. I should just say this. Or I should just, from Westlaw, sorry. So I have this memorized. Open up. Open up. Rational basis test. The rational basis test is a judicial review test used by courts to determine the constitutionality of a statute or ordinance. It's also referred to as rational review. Under this test, the statute or ordinance must have a legitimate state interest, and there must be a rational connection between the statutes/ordinance's means and goals. The rational basis test is one of 3 judicial review tests, alongside the intermediate scrutiny test and the strict scrutiny test. Both the intermediate scrutiny and strict scrutiny tests are considered more stringent than the rational basis test. So this is a really easy one. Like basically every single thing will survive. It should, unless you're like making the most random retarded laws ever. Okay, so, and then, hold on. Okay, so for intermediate scrutiny, this is a test courts often use in the field of constitutional law to determine a statute's constitutionality. Intermediate scrutiny is only invoked when a state or the federal government passes a statute which discriminates against, negatively affects, or creates some kind of classification affecting certain protected classes. This is described in further detail in the next section. To pass intermediate scrutiny, the challenged law must, 1, further an important government interest, lower burden than compelling state interest required by strict scrutiny test, and must do so by means that are substantially related to that interest. As the name implies, intermediate scrutiny is less rigorous than strict scrutiny, but more rigorous than the rational basis test. Intermediate scrutiny is used in equal protection challenges to gender classifications, as well as in some First Amendment cases. So let's say that I don't know if you would pass a law saying that like women's gyms are only for women or something, but like if you passed the law saying that, and your law is like men can no longer drive cars because that'll prevent them from getting into the gym, then that might like further a government interest. Like you would want to have women's only gyms maybe, but it's not like tailored narrowly enough to just preventing men. Like it's doing way more harm to do that. So you'd have to change that law there, because banning men from driving, I don't think is substantially related to that interest. It would have to be like more specific, I guess. The Supreme Court has ruled in multiple cases what constitutes an important government interest and therefore satisfies the first prong of intermediate scrutiny. The following list contains some examples of cases in which the court has acknowledged that certain state actions qualify as an important government interest within the meaning of the first prong of intermediate scrutiny. So you have prevention of teenage pregnancy, public health, national defense, physical safety of women. I wonder if this is like a gym thing. Insurance of biological relationship between U.S. parents. Okay. I don't know what this has to do with. I don't have time. Whatever else. Okay, and then sorry. Okay, so just the three bases of reviews are like decently like. There are good questions being dropped in YouTube chat. Oh shit! Did I miss something? If you ping my name or if you put my name in it, I'll usually see it. Rational basis review. Where are we at? Strict scrutiny test. Sorry. Okay. Okay. So strict scrutiny is your biggest test. So strict scrutiny is a form of judicial review that courts in the United States use to determine the constitutionality of government action that burdens a fundamental right or involves a suspect classification, including race, religion, national origin, and alienage. Strict scrutiny is the highest standard of review that a court will use to evaluate the constitutionality of government action, the other two standards being intermediate and rational basis. Once a court has determined that it applies, strict scrutiny starts from the presumption of unconstitutionality, shifting the burden of persuasion to the government, which must then produce evidence sufficient to show that its actions were constitutional. To that end, the government must show that its actions were narrowly tailored to further a compelling government interest and that they were the least restrictive means to further that interest. Although the terms are often conflated, the Supreme Court of the United States treats the narrowly tailored and least restrictive means and elements as analytically distinct. But okay, anyway, all that to say that the DC Circuit's holding that this unprecedented law satisfies strict scrutiny is indisputably certiorari worthy. So this sentence just means that the DC Circuit said that if you were to do a strict scrutiny analysis of this congressional statute that allows them to ban TikTok from operating in the US, that it would survive a strict scrutiny review, and a strict scrutiny implication is a very big deal, right? Because we know that strict scrutiny laws are implicating fundamental rights, okay, meaning really important things, and the group that they're targeting is suspicious, right? As in, like, I can understand why you might have like a women's only gym or a men's only gym. Why do you have a blacks only gym or a whites only gym? Like, these are like, now the classification is like very strange, right? So you have to make a very, very, very good argument here for why it should be allowed to be that way, right? But okay, so they're saying obviously the Supreme Court should talk about this. Isn't this what Rudy got confused about? I don't know. That Rudy Giuliani thing was impossible for me to understand. I don't know if he had a brain aneurysm or what, but okay. Speech restrictions have survived the Constitution's most demanding standard only in rare and narrow circumstances. This court should ensure that this critical protection has not been diluted by a decision upholding a law banning a speech platform used by half the country. To be sure, the DC Circuit portrayed its decision as fact-bound, saying there's persuasive evidence of national security risks identified by the government in the public record. My super gut instinct is there's no way this ban goes through, but I'm also reading their argument because I'm just trying to think from my perspective as a US citizen. If China were to invest in my company and they had a 20% stake, then theoretically, depending on how I operate, or if I were to allow people to post on my website or something like that, like I could come under, this is a huge, you're destroying my freedom of speech here, right? Which is okay. You can attack somebody's freedom of speech. You just have to have a very, very, very compelling reason to do so, right? But this court should ensure that this critical protection is not allowed to be sure that there's a fact bound, okay. But the court ignored critical gaps in the record before Congress during the act's hasty passage. Or still, the court's flawed legal rationales would open the door to upholding content-based speech bans in contexts far different than this one. Fear-mongering about national security cannot obscure the threat that the act itself poses to all Americans. Somebody said, should Russia have been allowed to invest in Tenet Company? Yes, there's no problem with that. The problem is that they hid it. They lied about it, which is a FAR violation, right? Does strict scrutiny really apply here? Let's say I'm banning McDonald's, but not Burger King. There's no protected class, right? Like, would that qualify as removing the right for fast food? No, you're banning my ability to have a company that does social media. That's definitely a fundamental right. It's freedom of speech, arguably one of our most important fundamental rights, right? But you would be a U.S. owner in that example, right? Isn't that what the bill wants TikTok to do? Remember, the bill said that there only has to be a 20% stake in a company for it to, for there to be a cause of action. A cause of action means there's a reason for a civil suit to go forth against your company. Unless I misread something. The controlled by a foreign adversary is an entity with respect to which a foreign person or combination of foreign persons described to subparagraph A directly or indirectly own at least a 20% stake. And this is an or, right? So it's either A or B or C, right? So does this apply to Tencent and Riot Games too? Hold on, were you listening? Were you listening or were you not listening in class, okay? It wouldn't because the covered company here, well, actually, I'm not sure. My guess is TikTok is probably gonna argue that it could cover these things. But the covered company, meaning the people that the action could be brought against by the federal government, is going to be companies that do all four of these things. I believe all 4 of these things are required. Permits a user to create an account or profile to generate, share, and view text, images, videos, real-time communications, or similar content. Has more than 1 million monthly active users. Enables 1 or more users to generate or distribute content that can be viewed by other users of the website. And enables 1 or more users to view content generated by other users of the website, desktop app, mobile app. I don't know if you can do this on League. You'd have to have like some social media part of it where you can post things that everybody can see. I'm not sure. If the government discovered some kind of serious exploit within TikTok's platform, would that make this more cut and dry? Well, if it was a law they were breaking, then sure, but. On the merits, the DC Circuit started on the right path by assuming that the act is subject to strict scrutiny. The government conceded that TikTok Inc. is a bona fide domestic entity operating domestically that is engaged in expressive activity through the creation of content on the platform. Damn, so the DC Circuit held this up under a strict scrutiny review, meaning that the DC Circuit feels that there is a very compelling argument as to the constitutionality of this. Now, different circuits can lean in different ways. Like, I think the meme is like is it the Ninth Circuit that's like California and them, where they're like, oh, this is the activist circuit, the activist judges, the liberals. I don't know if there's like a certain, I think like is it the Fifth Circuit, like Texas? Different circuits of appeal, Wikipedia, USA, where people will say like, oh, this circuit is always giving conservative rulings. There's some guy in the Northern District of Texas that's always sucking off corporations or something, right? These are your different circuit courts. And remember, regardless of location, a circuit court is always, I think, for federal cases. Although sometimes federal courts can hear state cases for some things, but it's different. But generally speaking, I'll say generally, because I think there are some weird exceptions where they can hear state law or whatever. But regardless, okay. On the merits, CDC Circuit started, the act applies only to covered applications on websites like TikTok that make the express choice to enable users to generate or distribute content. The act then singles out TikTok for disfavored treatment by banning applicants from operating TikTok without giving the benefit of procedural and substantive standards afforded to other covered speakers. Moreover, as the DC Circuit stressed, the act cannot be justified without reference to the content of the regulated speech, as one of the government's asserted concerns about Chinese influence itself references the content of TikTok's speech. Because TikTok Inc. is a U.S. company exercising editorial discretion over a U.S. speech platform, the First Amendment fully protects it from Congress's attempt to ban its operation of the platform based on its purported susceptibility to foreign influence. Strict scrutiny applies here, just as it would if Congress banned a specified American citizen from operating a particular American newspaper merely because a foreign nation might be able to control what he printed or misuse his subscriber data. They went fundamentally astray, however, in concluding that the act survived strict scrutiny. First, it held that Congress could ban applicants' operation of TikTok based on the risk of covert manipulation of content by China. But as in all strict scrutiny cases, the government bears the burden of proof. And here, neither Congress, the government, nor the DC Circuit identified any evidentiary basis to declare that the covert nature of any such risk could not be remedied through an express disclosure. That is how the First Amendment requires the government to address concern that the public is being misled about who is behind the speech they receive. Second, the court also held that Congress could single out TikTok as presenting the most pressing concern that China could improperly obtain U.S. user data. But the act inexplicably exempts numerous websites and applications that present no less risk, if not greater risk. That is kind of weird too, that like certain like review sites or whatever else is for some reason exempt. Sure. Such under-inclusion typically forecloses a determination that a law substantially advances the the interest asserted as required to satisfy strict scrutiny. So what they're saying that like, if you're really saying that the state is trying to advance this interest in such a precise way that implicates a fundamental right, then the way you've written this law seems contrary to that goal, right? Indeed, when this gross overbreadth as to covert Chinese content manipulation is paired with this gross under-inclusion as to data security, the strong combined inference is that Congress passed the act for a different reason entirely. Okay, I don't have to read this whole thing. So the question presented is whether the act is unconstitutional as applied to TikTok Inc. and ByteDance limited liability, whatever, because it categorically and uniquely prohibits them from operating the TikTok speech platform and other applications in this country. Opinion below and provisions involved. The DC Circuit's opinion is available in this bullshit. Jurisdiction DC Court exclusive jurisdiction statement. Okay. These are just statements of fact, I think. Okay. Why is Telegram not included? Don't know. Don't know enough about Telegram or how that operates, so. Okay. Okay, I don't think I need to read. Okay. So we'll call this an emergency application for injunction. I don't think I'm going to read all of these because I don't care that much yet. So an amicus curiae, curiae, I don't know how to fucking read this bullshit. Or fuck Latin. These are basically petitions that are, is it right to call it a petition? These are things that are filed by people who aren't parties to the case, but they want to support, I think it can be a litigant on either side. So maybe I'm like a law professor who studies First Amendment speech. I might want to file a brief to the court in support of one of the petitioners, and that's what these things are. I don't know if it has to only be like a plaintiff or a defendant. I'm not sure 100%. I think it might be able to be on either side, but just in reading these, it looks like these are all on behalf of the in support of the applicants. It looks like they're all in support of the applicants. I'm guessing. American Civil Liberties Union, Foundation for Individual Rights and Expression. Okay, well, hold on. We've got Mitch McConnell filed one. In opposition to emergency application. Oh, okay. So not all of these have. Okay, so you can file these for a different side. Damn. McConnell's like, fuck you, bitch. Okay. We can call this the docket, I guess. Just to have, this will give us updates on filing. Bullshit if we need it. Okay. Oral arguments. Trump submitted one too, but he didn't argue how SCOTUS should rule. Oh, sure. I would be highly cautious in reading anything from an attorney that Trump hires. Trump attorneys have demonstrated in the past that they are legally and potentially even like English illiterate. They have no respect for or understanding of anything related to legal matters. I don't know if it's like ChatGPT generated shit or if they just forgot everything in law school, because people like Powell or Giuliani, a lot of these people who are now disbarred, just make the most specious, both legally and factually, arguments in the history of the world. There's no value unless you're just trying to figure out like, well, what do they think or what crazy shit are they up to? It's an embarrassment to the profession, the states that they're from, and the United States in general, that these people are putting pen to paper for literally anything submitted to any court ever. It's actually fucking insane. But regardless, all right.
Okay, y'all. I can talk to you about it later. Yes.
For the Supreme Court, I don't know why, because of tradition or they're too lazy to do their makeup or something. I don't know. You're not allowed to have video recordings, but you are allowed to record audio. And that's why we get audio, but not video.
Does anybody want me to call?
C-SPAN's cameras live outside the Supreme Court for the case dealing with TikTok and the potential ban of the app in the United States. Also let you know, over on C-SPAN today, we could see President-elect Donald Trump scheduled to be sentenced on felony charges 10 days before he's inaugurated for his second term. And if we hear from those exiting the courthouse today, from Juan Merchan's sentencing there,
Mr. Chief
versus Garland and the consolidated case. Mr. Francisco.
Mr. Chief Justice, and may it please the court. Under the Act, one of America's most popular speech platforms will shut down in 9 days. That shouldn't happen for 3 reasons. First, TikTok Incorporated is a U.S. company speaking in the United States. The Act requires it to go dark unless ByteDance executes a qualified divestiture. Whether you call that a ban or a divestiture, one thing is clear. It's a burden on TikTok's speech, so the First Amendment applies. Second, the Act is content-based from beginning to end. It applies only to social media platforms that have user-generated content, except for business, product, and travel reviews.
Remember, so I don't know if the other, I'm guessing this, I will make this argument. If you're an individual, you always want to argue for the highest level of scrutiny because it makes the burden fall on the side of the government. So of course, TikTok and ByteDance are going to argue for a strict scrutiny review. My guess is the other side is going to try to argue a lower review. I don't know if they would go all the way to rational basis or intermediate, or maybe they just wouldn't give a fuck. But you want to have the highest burden possible on the government because they're the ones taking action issues. That's where this argument is starting. That makes sense, right?
Within that content-based universe, it singles out a single speaker for uniquely harsh treatment. And it does so because the government fears that China could, in the future, indirectly pressure TikTok to disseminate foreign misinformation and propaganda. Finally, the Act can't satisfy any standard of scrutiny. The government has no valid interest in preventing foreign propaganda, and its fallback that it seeks merely to prevent covertness makes no sense, since that could seek preventing standard of scrutiny.
Hold on.
The government has no valid interest in preventing foreign propaganda, and its fallback that it seeks merely to prevent covertness.
So for the government has no interest in preventing foreign propaganda, I think strictly speaking, that's true. It's not illegal to have foreign propaganda in the United States. Now, there are laws that mean you have to declare if you're like a foreign entity, for instance. So I brought up FAR before, the Foreign Agent Registration Act, but it's not like illegal to do foreign propaganda. You could be a Russian company, come to the United States of America, and then do propaganda for Russia, as long as you like have announced everything that like, yeah, I'm a foreign registered agent. Or if you're an American, you can do propaganda for other countries. There's no law against that. So you don't have. One of the phrases I'm using is cause of action. There's generally when you sue somebody, there has to be like a reason. Your cause of action is why you're suing them. And the federal government doesn't have a cause of action because you're doing propaganda. So it has to be, you have to make a different argument, right?
And its fallback that it seeks merely to prevent covertness makes no sense, since that could be addressed with a risk disclosure. The government's real target, rather, is the speech itself. It's fear that Americans, even if fully informed, could be persuaded by Chinese misinformation. That, however, is a decision that the First Amendment leaves to the people. Given that the government's data security rationale cannot independently sustain the Act, it is also grossly under-inclusive and ignores the most obvious, less restrictive alternative, simply banning TikTok Incorporated from sharing any sensitive user data with anyone. In short, this Act should not stand. At a minimum,
how do we handle that imbalance? Should we allow it? If we can't have a social media company pushing American interests in China or Russia, why should we allow it here? Because that's how our laws work, because freedom of speech is enshrined in the Constitution. So if you want to get around that, there's 2 ways to do it. You either get rid of that First Amendment protection, you abolish the First Amendment, or you pass another amendment basically overruling it or nullifying it, or you pass a law in Congress to limit this type of speech in such a way that it comports to the Constitution, and the Supreme Court agrees, right?
Anyone. In short, this Act should not stand. At a minimum, you should preliminarily enjoin it, which will allow you to carefully consider this momentous issue and, for the reasons explained by the President-elect, potentially moot the case. I welcome your questions.
Exactly what is TikTok's speech here?
TikTok, Your Honor, uses an algorithm that, in its view, reflects.
Okay. So I don't know if I'm pausing too much, or we can just listen to it. When they say, what is TikTok's speech here, right? The question, was that Thomas? The question is like, does TikTok have a First Amendment stake here? I thought you were just hosting other people's speech. What is the speech that you're referencing? Because if it's not your speech and somebody else's, would the First Amendment even apply? I'm not actually sure. So they have to make the argument for why the First Amendment would even apply here, right?
Here.
TikTok, Your Honor.
Exactly what is TikTok's speech here?
Does anybody know who that was? Was it Thomas? I'm not sure.
TikTok, Your Honor, uses an algorithm that, in
Wait,
its
does C-SPAN not say at all who's speaking? Certainly they're going to do that, right? Could you argue that non-U.S. citizens / companies do not have those protected rights? Or has this question been asked? If you know, I don't know how laws apply to non-U.S. citizens, but it doesn't matter because this law would apply to U.S. citizens and U.S. entities, so it doesn't matter.
reflects the best mix of content. What the act does is it says TikTok cannot do that unless ByteDance executes a qualified divestiture. That's a direct burden on TikTok speech, much less of a burden than the one that this court struck down in the Simon & Schuster case, where all the author had to do was take a certain amount of proceeds and put it into an escrow account for a short period of time to satisfy a civil judgment.
So why does a restriction on ByteDance, which is not a citizen, is not located in the U.S., a restriction on TikTok?
Because what the law says to TikTok is that TikTok, you cannot use the algorithm that you prefer to use unless ByteDance executes a qualified divestiture. So the law therefore falls directly on TikTok itself. It imposes a burden on TikTok speech, again, a much more significant burden than the one that was struck down in Simon & Schuster.
So you're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok speech. So why can't we simply look at it as a restriction on ByteDance?
Because I think the burden falls directly on TikTok. And I can use a hypothetical that helps illustrate the point. Suppose that China used its leverage over Jeff Bezos' international empire, including his Chinese businesses, to force the Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff Bezos, you need to either sell the Washington Post or shut it down. That wouldn't just violate Mr. Bezos' First Amendment rights. That would also violate the Washington Post's First Amendment rights, because they are ultimately the one that's suffering the burden under that law, because they have to go dark and close up their books.
Counsel, you began by saying this is...
Okay, I hate Thomas. Because he's an un-American traitorous fuckboy piece of shit. Not fuckboy, he's a fucking loser, sorry. I thought his question was dumber originally, but actually I think Thomas's question was good here. How does this burden TikTok the company? Because that's what they're arguing for. How is this not just burdensome on the company that owns TikTok, right? Because how is this implicating like TikTok's First Amendment right to do speech or whatever, rather than just, I guess, the owners of TikTok, which would be ByteDance here? I think it's probably maybe a fair question. I think sorry.
They have to go dark and close up their books.
And so he's comparing like, well, what if Bezos owned the Washington Post and somebody tried to sue Bezos because of something that he said the Washington Post needed to publish or whatever, or something? This wouldn't be burdensome just to Bezos. It would also be burdensome to the Washington Post as well, right?
So you began by saying this is a U.S. company operating in the United States.
Yes, Your Honor.
But the ultimate company that controls it, ByteDance, was found by Congress, and I quote this, to be subject to Chinese laws that require it to assist or cooperate.
Name all the justices? I don't know what these fuckers look like. This loser is Roberts, who's crazy. Thomas is even more crazy. I'm guessing this guy is, I think, Alito, who's also unhinged. These two are the most unhinged. They're brothers in crime in the worst ways. This is our Queen Sotomayor. This is Kagan. I think this guy here is a Kavanaugh. This is Gorsuch. Gorsuch writes very well. I've never seen him say something retarded. Kavanaugh, I think, is okay. I don't think I've seen him say anything too retarded, but I haven't read a lot of Supreme Court cases. Amy is our based goddess swing voter who would be, I think, our swing vote if the Supreme Court hadn't been rigged by McConnell when the Democrats lost our Supreme Court pick. And then this is Jackson or Brown. I forget which one her last name is. Did I get him? Oh, I think that's that right.
With the Chinese government's intelligence work, quotes, and to ensure that the Chinese government has the power to access and control private data that the company holds. So are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
Well, Your Honor, I don't think you are supposed to ignore that at all, but I also don't think that it changes the analysis for a couple of reasons. Look, TikTok and...
Well, just hold a second. Well, as I said, you began by saying this is a U.S. company operating in the United States, and it seems to me that you're ignoring the major concern here of Congress, which was Chinese manipulation of the content and acquisition and harvesting of the content.
Sure. And I'll start by saying that TikTok Incorporated is a United States subsidiary operating in the United States with its own set of free speech rights.
Do you dispute the fact that ByteDance has ultimate control of TikTok in its corporate organization?
Yes, Your Honor, I do dispute that, but I also don't think that it matters, because even if China could exercise overwhelming power against TikTok versus ByteDance, I don't think it would change the analysis. And I can take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point. Let's suppose that the Chinese government had actually taken the
like you have a First Amendment right to freedom of speech. I don't think you can just axe somebody's First Amendment because somebody else is exercising control over them. I think you need a more compelling argument there. That's what I think Francisco is arguing.
Bezos' children hostage. And it was using that leverage in order to force Bezos and the Washington Post to publish whatever they wanted on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down, because that would violate Bezos's rights and the Washington Post rights. Maybe what they could do is come in and say, you need to disclose the fact that you're under this amount of coercion.
Correct, because so I don't know if he's implicating FARA, that law directly, but you can't just shut somebody's freedom of speech down because another country is paying them. Remember, that's a big, big, big right.
So that the people who are looking at the paper understand it and can make their own assessment. But I think the First Amendment rights of both Bezos and the Post would be directly implicated, notwithstanding that China in that scenario has effectively total control over what gets printed in the Washington Post.
Counsel, let me break this down. I understand your argument that there is a First Amendment right that the U.S. company has. I'll go that way.
Wait, holy fuck. Is this going to survive? I'm getting bad vibes right now. Wait, I'm feeling bad vibes right now. Survive as in like the law is going to survive and TikTok is going to be axed. But I don't even know if I have strong, because I haven't even heard the other side's arguments yet. Maybe they're really good arguments that I just don't know because I don't have a huge constitutional. Okay, well, listen, okay.
Far with you, okay?
I'll take it.
Because we're affecting their ability to talk in whatever way they choose. The Washington Post could choose without any influence or threat against the children of Mr. Bezos to promote Chinese policy, and our First Amendment would permit them to do that if they chose it independently, correct?
Yes.
Correct.
Now the question becomes, so it's not, that's just a given that they have a First Amendment right.
To promote another country's interests.
The next question is, assuming they do, what's the level of scrutiny we apply?
It's always going to be, for the First Amendment, it's always going to be strict scrutiny, I believe, right? So they're back to what basis of review do we use?
Isn't that what the issue here?
That is certainly one of the issues, Your Honor.
All right. So if we get to that side of the issue, that TikTok USA has some sort of First Amendment right, taking your example, if the government said no speaker is free to speak under a criminal compulsion by someone else because of extortion, because of kidnapping, we are doing this because it is the only way to ensure the safety of people, that they are not going to be kidnapped or threatened, their lives threatened.
Jesus. Sorry, hold on. Somebody said, wasn't Destiny against removing it from the start? Okay, hold on. Please listen. I don't remember what my opinion is at the start. I don't know what I said at the start. And by the start, I mean like months ago. Okay? When somebody asks a question of like, are you for or against getting rid of a particular thing, you know, in the United States? If you're going to ask a legal question, then that demands a legal analysis. So that's why before going to the oral arguments, I wanted to read at the very least the request for the writ of certiorari or whatever, and then just have some understanding of what the case is about. Because like I might say something like, somebody might say, oh, they wanted to ban TikTok for national security interests with the president. And that might sound like a legal argument. Oh, okay, national security, sure. And I say, yeah, I guess that's probably okay. But let's say that the law they passed to do it was, the law says the president at any point in time can dictate any country as an enemy to the US. And if any platform says anything good about that country, then that's a compelling national security interest to ban that. Boom. In that case, even if I'm for banning something for national security interest, the legal analysis would be like, no, what the fuck? The president can't just declare anybody an enemy and ban the thing. Legal analysis is important for legal things, and it's different than just an opinion. Now, I know that like everybody wants to have an opinion about everything, especially fucking political commentators, okay? But to have an opinion about a legal case, it should be done through the lens of a legal analysis, okay? To be clear, I don't have a formal legal background, and I haven't read the defendant's side of this, so I don't know what Garland or the DOJ or anybody on his behalf filed on their side, so I haven't even seen their arguments. So it could be really compelling arguments on their side. But just on its face, the idea that Congress could pass a law that allows the president to ban any social media company as long as there's a 20% equity holding from a foreign adversary, I don't know how I feel about that. I don't know if that feels to me like something that should survive First Amendment protections. I'm not convinced of that, but maybe I will be by the end of this. We'll see.
To be kidnapped or threatened, their lives threatened. You don't think that the government has a compelling state interest in saying, if there is a threat, a physical criminal threat against someone to do some activity, that the government couldn't say, I'm not questioning whatever the content is of that activity. I'm simply saying we, in our governmental powers, have a right to say, you can't do that.
No. It has to be specific, right? So like looking at, say, one thing that I brought up with Pisco is like the Brandenburg test. Just because something might lead to something bad doesn't mean, even if it might lead to like harm or people dying, that's not enough to go against somebody's like right to free speech, right? So like when it comes to inciting like a riot, right, for Brandenburg test, in order to criminally charge somebody for incitement, the Pisco said there were 4 elements. I thought there were 2. This says 2. Maybe there were 4 in some other place, right? So in order for this, the speech is directed to inciting or producing imminent lawless action, and the speech is likely to incite or produce such action. I think broad threats or broad claims about Jews or national security or whatever, I don't think they would ever survive, at least for the crime of advocating legal action. So I think it has to be more narrowly tailored, whatever law you're making, to make some kind of speech illegal. It needs to be more narrowly tailored than to just say there's some national interest. However, again, remember, because I don't have a legal background professionally or academically or whatever, there could be that the state or the president might have additional ability to say that I can criminalize something. Like maybe there are some things here that aren't like on an individual level or something that I just don't know about, but we'll hear about it. Okay.
So powers have a right to say, you can't do that. You can't speak.
Sure, Your Honor. So to take your question in pieces, I do think that they would have a compelling interest in that scenario to do something. But what I don't think is that they could simply target speakers in speech. Take, for example, generally applicable laws like the
So you think in that situation that the only thing the government could do is tell the Washington Post, disclose to the public that you are saying this because you are being forced to.
Yes.
So, sure.
That's the only remedy the government could undertake?
No, Your Honor, but I want to make sure
Well, what else could they do? I mean, if we're saying like threaten them, like by extortion or blackmail, then that would be bad. But those are separate crimes, right? Those are all crimes already.
understand the hypothetical. The compelling interest is in preventing this kind of compulsion, coercion, and ultimately harm to children. And I think that the government has a lot of different ways they can address that through speech-neutral laws. And I was going to point to things like the Trading with the Enemy Act or Russia sanctions. You can broadly say and attack problems.
They haven't been very effective.
Well, be that as
we're still having people kidnapped. We're still having coercion.
And be that as it may, you can say to Americans, you cannot collaborate with our enemies at all. And if you do that, you're going to be severely punished for doing that.
All right, we can
But
go on to the effectiveness of the remedy. But the point is, I believe, that even if your First Amendment rights are impinged and there is some protection, the question is at what level of scrutiny?
Yes, Your Honor.
And whether that the action is content neutral or not.
I agree that that is the way that the analysis proceeds. Here, we believe that the level of scrutiny should be strict scrutiny.
What is the relevance?
Why are the judges allowed to just interrupt them? That's mean, okay? They should have to say, excuse me.
That the level of scrutiny should be strict scrutiny.
What is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the D.C. Circuit, emphasized that there is a long tradition of preventing foreign ownership or control of media in the United States, going back radio, television, and what have you. I would think no matter the level of scrutiny, that history has to be important, and I want to get your response to it.
I don't actually think it's important in this context because that history all arises.
And what have you, media in the United States going back as a Srinivasan. What is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the D.C. Circuit, emphasized that there is a long tradition of preventing foreign ownership or control of media in the United States, going back radio, television, and what have you. I would think no matter the level of scrutiny, that history has to be important, and I want to get your response to it.
I don't actually think it's important in this context because that history all arises in the context of bandwidth scarcity. And in that context, you have the government that's in the position of doling out a limited number of licenses. And when you have to dole out a limited number of licenses, you by definition have to pick winners and losers. And when you have to do that, you get a certain amount of discretion. I think that's the whole basis of those cases. You can't really take those cases
keep going.
You can't really take those cases and extend them to an area where there is no scarcity like the World Wide Web. Because once you do that, there's really no limiting principle. There's no reason why it wouldn't also apply to really popular books or magazines or newspapers or chains of newspapers. The bandwidth scarcity, I think, is really what justifies the greater discretion that the government gets in that area.
Mr. Francisco, let me see if I can break this.
So that was interesting. So was that Gorsuch? Fuck.
You can't really lose the devices in the condition of doling out a
Oh, that was Kavanaugh. Okay, that was Kavanaugh. So Kavanaugh brought up, I don't know what this case is exactly, but Kavanaugh brought up the idea that like there's a history of media not being owned by foreign companies, and this court case that's brought up. And Francisco is, I imagine they either just have a huge library of knowledge or they know which cases are going to be brought up. Well, it sounds like this one was specifically referenced by the lower court, and the argument as well. It seems like in the past we've like doled out licenses are not based on, you know, who the owners are or national security interests or whatever, maybe something like that. And Francisco's argument is, well, hold on, these are licenses for, like, there's a limited number of these. This is way different than trying to ban a social media company. It's not like there's a limited amount of space on the internet or there's a limited amount of bandwidth or something and we have to choose like winners and losers. This is a speech law that's being made that abridges or obstructs my First Amendment right for no compelling reason. There's not a limitation here that would apply like it would in that other case.
By the People's Republic of China. That
Scarcity, I think, is really what justifies the greater discretion that the government gets in that area.
Mr. Francisco, let me see if I can break this down. Suppose that TikTok were outright owned by the People's Republic of China. Would you make the same argument?
I wouldn't be making the same argument, Your Honor.
Why not China? Would you that TikTok were outright owned by the People's Republic of China? Would you make the same argument?
I wouldn't be making the same argument, Your Honor.
Why not?
So he's saying, what if TikTok was just owned by the People's Republic of China? Would you make the same argument? And he's saying he wouldn't make the same argument. My guess is a lot of this strict scrutiny, the argument for the strict scrutiny review is going to be that TikTok is a U.S. company. So all of the First Amendment rights apply. If this was wholly owned by a foreign entity, I don't know if they would enjoy the same constitutional protections.
Because there you would have to confront a very different question, whether a foreign government that was speaking in the United States has First Amendment rights, and I don't know that the court has ever addressed that. But here we've got a U.S.
No, I understand that. I just want to see where you draw the line. So it's true, the court has never held that a foreign government has free speech rights. And if we were to hold that, I would think it would be because speech by a foreign government, particularly one with enormous resources, is not protected. Allowing that does not serve the underlying interests of the First Amendment, which are, among other things, fostering democratic self-government and furthering the search for truth. So let's assume that we start with that. All right. What if TikTok were then not owned by the foreign government, but it was undisputed that TikTok was totally controlled by the foreign government, could not do one thing without the approval of the foreign government?
So somebody in chat asked, what's the difference if they own them or not de jure, but they de facto control it? So de facto means that not by law, but basically like it is the case. And de jure means like it's not delivery, it's DiGiorno. I need clappers for that. I'm sorry. De jure means it's written in law that they do control it. So now Alito is asking this question. Fuck you guys.
By the foreign government. Could not do one thing without the approval of the foreign government. That's different?
I do think that it is different, Your Honor. For example, I've given the hypothetical that I've given, but there are a lot of companies in this country that have foreign owners, not just companies like Politico, which is German-owned, or Al Jazeera, which is partly owned by the government of Qatar.
Well, I understand that, but what would be the reason for drawing that line?
Sure,
if there's a good reason for saying that a foreign government, particularly an adversary, does not have free speech rights in the United States, why would it all change if it was simply hidden under some kind of contrived corporate structure?
Because
I feel like the strongest argument in favor of the TikTok side here is because if you were to say, let's say that you are basically controlled by a foreign government, well, we wouldn't want to give that company freedom of speech. Sure. What about an individual then? What if it comes out that, or what if I even freely say, China's just like telling me like, hey guys, we're going over Chinese talking points today. This is where they email me. Let's go. Could the government come after me and shut my speech down because I'm getting direct, even if I was and I admit fully, like 100%, like China tells me everything to say, would I be implicated there? I feel like, I don't think, as long as I'm making my responsible disclosures or whatever, I'm not receiving money and not disclosing or something, I don't think the government could come after me for that. Should they be able to? I don't think so. But
if it was simply hidden under some kind of contrived corporate structure.
Because it is a U.S. speaker.
Yes.
I'll give you another example. AMC movie theaters used to be owned by a Chinese company. Under this theory, Congress could order AMC movie theaters to censor any movies that Congress doesn't like or promote any movies that Congress wanted. And I think the reason is that here, where it's conceded, you actually have a bona fide U.S. company. It is not simply a Chinese cutout that is the Chinese government speaking itself.
That's true too. The facts, that's not something that's being alleged here even, is that TikTok is a 100% foreign directed company. So it's not really fair for that consideration to be made because it sounds like the DOJ didn't even make that contention. They already conceded, yeah, TikTok is a U.S. entity, sure. We agree with that, yeah. And then they're moving from there, right?
Not simply a Chinese cutout that is the Chinese government speaking itself.
All right,
but
let's
an
say that's not
independent
a
United States company.
Let's say this is not a complete answer to your First Amendment argument, but would you be willing to concede that this is a very important factor that should be taken into account in deciding whether there's a First Amendment violation.
Would this be an important factor? Whether there's a violation, is it whether there's a violation or whether or not the government can make the law against it? It would be an important factor, right? Because it's one of your two prongs, like the compelling state interest, but you have to satisfy the second one, which is showing you're making a narrowly tailored, like a speech neutral law, I guess.
Well, Your Honor, I think that it does help supply a compelling governmental interest, but I still think you have to march through the strict scrutiny analysis and analyze
and have the
their
narrowly
interests.
tailored, yes,
I do not think that they have a compelling governmental interest in the manipulation of content. I think that is in the teeth of the First Amendment, and if you look at the government's brief and the rest of the record in this case, that's really what it's focused on. Their complaint is the fear that the content could be critical of the United States government or could undermine our democracy. Yes, Your Honor.
Mr. Francisco, I just wanted to follow up on that line of questioning with just some fact questions, because it seems to me there are a couple of things that the parties still dispute about facts in this court, which is a little unusual. The government says that TikTok, U.S., has no authority or ability to alter the algorithm or recommendation engine, but must simply follow ByteDance's directives. You disagree with that in your reply brief.
Yes,
somebody has to be right and somebody has to be wrong about that. What's the fact? What does the record show?
Well, Your Honor, we are.
So I believe, I think legally there's something called a court of first review. I think is what I don't need to guess any of this. We can just Google this. But when a Supreme Court is deciding something, unless it's a case they have original jurisdiction over, that they're the first people that hear it, the Supreme Court, I don't think, typically considers questions of fact. It is not considering what the facts of the case are in terms of what's right or wrong. They're just considering the legal question about it. So, like, if something gets to the Supreme Court and it has to do with anything, with whether Trump gets like the Trump immunity case is a good example. The Supreme Court is not there to decide, okay, well, do we think that he did this thing or did he not do this thing? I think the Supreme Court just accepts the facts as presented to it from the appeal of the lower courts, and then it's only engaged in matters of legal review, not a factual review, I believe. Except maybe when they have original jurisdiction. So if they're the first court to hear a case, like if a state brings a case to it, but I don't even know in that case if they ever do a fact review. I'm not actually sure, but yeah, okay.
We are here on a record, and there is nothing in the record that says that TikTok, like any other subsidiary, doesn't have its own independent making authority. If you look at their record sites, what they point to is the ordinary types of control that a parent company has over a subsidiary company, but it doesn't change the fact.
All right, what is the fact? Are you prepared to make a representation?
Yes, Your Honor.
Here?
The fact is that.
I wonder why, should you even have to answer this? If the other side's not contesting these facts, then why even bring it up? You know, they didn't even fucking bring this shit up. We don't have to talk about the facts here. They're not relevant. Isn't the argument that TikTok does have freedom of speech, but because ByteDance is directing its speech and China does not have free speech in the U.S., Congress can regulate its speech? I don't believe that's the argument that the Department of Justice is making here. So I don't think that should be an argument that's up for consideration for the Supreme Court. Right?
TikTok Incorporated, as a U.S. company, does have a choice over the algorithm. Now, it would be an incredibly bad business decision for them to abandon this algorithm, and they very doubtful would ever do it, but they have that authority. What they clearly have the authority to do is shut down the platform in the face of Chinese pressure. That's actually what they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated, as a U.S. company, does have its own set of First Amendment rights.
Okay. And then
somebody said Supreme Court doesn't do first review. The Supreme Court, I believe, does have original jurisdiction in certain cases. One of those would be, I think, when states sue other states. I believe that the Supreme Court has its original jurisdiction is what I'm saying, right? They're the ones who have the first look. But I don't know if they then do factual consideration there. Original jurisdiction refers to a court's authority to hear and decide a case for the first time before any appellate review occurs, yeah. But I don't know if they do fact-finding there or how that works. I'm not sure. But
scores why TikTok they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated, as a U.S. company, does have its own set of First Amendment rights.
Okay. And then another fact question. Before the D.C. Circuit, you argued that the Chinese government has made clear in public statements that it would not permit a forced divestment of the recommendation engine. Does that mean that some key component of the recommendation engine is under Chinese control?
No, Your Honor. What it means, and this might warrant a little more explanation, what it means is that there are lots of parts of the source code that are embodied in intellectual property that are owned by the Chinese government, and they would restrict, like the United States restricts the sale of those types of things to foreign governments. It doesn't alter the fact that this is being operated in the United States by TikTok Incorporated.
Okay.
So
I got it.
Okay.
I got it. And then you represent that the divestiture is not feasible within the Act's time frame. I'm sorry for these fact questions,
Sure.
but I just want to understand what's before us.
So the Act's time frame that we read, I think the divestiture had to happen within 180 days, which is 6 months, which does seem like a pretty accelerated timeline. If we consult the Act itself, I think it was 180 days. It might have been 90 days. It was either 3 months or 6 months. But it's pretty accelerated, pretty quick time frame.
Would it be feasible in any time frame? I take the government doesn't dispute that it's infeasible in the 270 days provided by law. But would it be feasible?
Your Honor, I think at least as we understand how they've interpreted the qualified divestiture provision, it would be exceedingly difficult under any time frame for two principal reasons. The first is that there's a global team of engineers that are some in China, some in Europe, some in the United States that maintain and update the original source code.
Is it accelerated? What is the usual time frame for divestment? For companies of this size, my guess is that you're going to need like a minimum of 2 years, would be my guess. Because there's a lot of fucking process and procedure in different companies and like over different countries. I mean, maybe you could accelerate it more than that, maybe 1 year, but.
And as we understand their interpretation, a qualified divestiture would prohibit any kind of coordination with that global team of engineers. The other reason.
Ooh, that part, what he just said, unless I'm misunderstanding something, and I must be misunderstanding something because I'm sure he's aware of this. I don't think that what he just said is true because I thought that the Act explicitly exempted people who are helping companies qualify for divestiture. Jesus. So this is for exemptions for certain necessary services. Subsections A and B do not apply to services provided with respect to a foreign adversary-controlled application that are necessary for an entity to attain compliance with such subsections. I thought those people were exempted, but maybe I'm misunderstanding that. Sorry.
Some in the United States that maintain and update the original source code. And as we understand their interpretation, a qualified divestiture would prohibit any kind of coordination with that global team of engineers. The other reason is because, as we understand how they're interpreting it, a qualified divestiture would divorce the U.S. platform from the global content. So, for example, there are videos created in the United States. There are videos created in Ireland. In order to get global content, we need access to the Irish videos. They need access to the U.S. videos.
I got
We
that.
understand that couldn't happen.
Okay, so you think it's probably not feasible in any timeline?
Well, Your Honor, I think it'd be extraordinarily difficult.
Okay, last fact question, then I'll yield the floor here. The government admits that it has no evidence that TikTok has engaged in covert content manipulation in this country, but says that ByteDance has responded to PRC demands to censor content outside of China in other countries. Again, you deny that in your reply brief, Somebody has to be right about that.
Well, Your Honor, the problem there is everything that follows what you just read is redacted, and so I don't know what it says. What the record shows is two things. The record shows, first, what you just said. They haven't done anything here in the United States with respect to TikTok Incorporated. And second, the record also shows through our transparency reports that we haven't removed or restricted content on the TikTok platform in other parts of the world. And TikTok doesn't operate in China, it operates in other parts of the world. We haven't removed or restricted content at the request of China. That's what we put out in our regular transparency report.
Remember, one of the reasons why the factual record is so important, the factual record doesn't just mean what's true. That would be like a fact. It's the record of those things as relevant to the court case. So if somebody were to submit a case to a court saying that I am a danger to society because I'm like 9 feet tall and I shoot javelins out my cock, and then I were to argue in front of a judge, or I were to argue in a lower court that like my javelins actually aren't harmful, that I don't shoot them, or whatever. Blah, blah. By the time this makes it to the Supreme Court, the factual record that they have before them to consult is the factual record agreed upon by the lower courts. So even if they know something might not be true, or it looks ridiculous, or they want to say like, well, doesn't China do this, or doesn't that? It doesn't matter what you think personally. What matters is what was the factual record before the court that was decided by the lower courts, then the appellate court, and then up to you before it got to you. There might be some exception if it's like a super ridiculous thing, but in general, but I don't think that would survive that far, right? But yeah, so you can't consider facts that aren't outside of what's already been considered, or if you do, that's a big no-no, I believe. But
Restricted, though, doesn't necessarily cover covert content manipulation, though, right?
Well, Your Honor, I'm limiting my response to what's in the record.
Okay.
It's very
which you should be doing, right? Yeah.
difficult for me to respond to things where I don't know what the accusation is.
I have other questions.
Because to respond to things outside of the record, well, you don't fucking know. Anybody could say fucking anything. Who the fuck knows? If nobody wants to submit it to a court and actually argue it, I'm not going to respond to statements made by the press or people in the media, or made to the press or made to the media, like put them in a court record and then we can argue about it there. Yeah.
Questions about the secret evidence in this case, but we'll get to that later.
Yes, Your
Mr.
Honor.
Francisco, can I ask you a question about the relevant speech here? So it's
Okay, wait, let's just mark where we think these people are at. Okay, so fuck, I should have been writing this down from the beginning. Let's see. So far, Thomas has talked about it. Roberts has talked about it. We just heard Kavanaugh talk about it. So Sotomayor spoke about it. Thomas, Roberts, Alito was at the, and then we just listened to Kavanaugh. Fuck, I should have been writing down just generally why I felt like they were against it. I should be writing down why. These are my feelings. Kavanaugh so far seemed like neutral against it, I guess. But I don't know. We'll see. We just heard Gorsuch. Oh, wait, that was Gorsuch speaking? I'm sorry. I don't know why I did this in the dumbest thing. Okay, sorry.
strikes me that this is a little different than your Bezos example, because there it's clearly content discrimination because we're talking about the ability to post particular articles versus other articles. Am I right that the algorithm is the speech here?
Yes, Your Honor. I would say it's, the algorithm is a lot of things. The algorithm has built within it, it's basically how we predict what our customers want to see.
The editorial discretion.
Yeah, the editorial discretion. It also has built within it the moderation elements. All of this kind of comes together when the source code is translated into executable code in the United States. In the United States, that executable code is then subject to vetting, review, moderation through content moderation algorithms, and so it ultimately lands on the TikTok platform.
But what we're talking about as a net choice is the editorial discretion that underlies the algorithm. And I just want to be clear, a lot of your examples talk about, including the Bezos one, the right of an American citizen to repeat what a foreign entity says, or say, I'm hitching my wagon to China, I want to say everything China does. Here, the concern is about the covert content manipulation piece of the algorithm.
I feel like there's so many fucking insane things were said about Justice Barrett. Maybe they were true. I'm not sure. Everything I've read by her is so good. Fuck me. But this is a really interesting distinction that she's making, right? So what is the freedom of speech thing being implicated here? Because in your analogy, so she's teasing apart that analogy with Bezos and the Washington Post, right? And the argument that the plaintiffs are making here, the attorney Francisco, he's saying that if you were to go after Bezos because of stuff that the Washington Post is publishing, right, you're implicating the free speech rights of even the Washington Post is going to be burdened here, basically, right? And then so is Bezos, obviously. And what Amy is saying is, well, hold on. An American writing a post is probably a different kind of free speech than how you would tailor an algorithm. And what's being alleged here isn't even the tailoring of the algorithm. It's the tailoring of the algorithm for the purpose of some kind of subversive, covert foreign manipulation. So is that protected speech? She's drawing a distinction between those two things, which is a good distinction to draw. However, I still think the response from Francisco would be, if somebody is not disclosing it, that could be illegal under things like FARA, but as an American citizen, you still have the right to do that. You have the right as an American citizen to take foreign direction for propaganda purposes. You can't censor somebody's freedom of speech because you don't like that they're doing foreign propaganda as long as it's being disclosed, which is why Francisco's argument earlier was there could be other ways to deal with this. The Congress could force you to do some kind of disclosure, a different kind of disclosure, even a heightened disclosure if they want, but you can't come after the company and take away their freedom of speech for that. That was his earlier answer. I don't know how he'll say here, but.
That is something that ByteDance wants to speak, right?
Well, Your Honor, I think that ultimately it's TikTok's choice whether to put it on the platform.
And you don't want that. Is your client disclaiming
we absolutely resist any kind of content manipulation by China at all. But what I do want to focus in on is what their asserted interests here. They do talk about covertness, but it can't possibly be that all they're concerned about is mere covertness. If all you were concerned about was
covertness, then the law would just be to disclose. He's going to repeat the argument from earlier, right?
The covertness, untethered from the underlying content, that's something that could be easily addressed through a risk disclosure.
But that goes to scrutiny, the level
Yes, Your
of
Honor.
the application. I'm trying to, let's say that.
Oh, but so that's a good point too. That goes to scrutiny, meaning if they're trying to make a law passing, no, that's not a good argument. Because if they're making a law about whether or not it should be disclosed or not, right? A law about disclosure might be an intermediate scrutiny. There might even be just a rational basis. Because does disclosing something even implicate a fundamental right? But what Francisco is saying is Congress is clearly not targeting us because of the disclosure or because of foreign influence, because then they would just make us disclose it and now we're done. They don't like the speech itself. They're targeting the speech itself. The reason why they don't like the algorithm is because they think that China's manipulating it in a way that is doing foreign propaganda. That's what they're trying to get rid of, and that implicates First Amendment right, which demands a strict scrutiny review.
I agree with you, the First Amendment is implicated, and I'm trying to figure out what level of scrutiny applies, and I'm trying to figure out what content, if any, discrimination is going on here. There's a disproportionate burden. Let's say that I agree with you about that. No one is preventing you. You're seeking access to a particular source code, engineering, the recommendation feature. It's the technology that you want. You're not trying to repeat, as in the Bezos example, if we take the speech that the government's concerned about to be the covert content manipulation rationale, you're not seeking to utter that speech.
That's correct, Your Honor. What we are seeking to do is use an algorithm that displays the combination of content that we prefer our users to see on the platform.
And the government doesn't care about that. The government is fine with you doing that.
Well, she says that, but his argument is contrary to that. The government's not fine, because if the government was fine with that, then they would be forcing a different type of law about disclosures rather than trying to ban it entirely, right?
You can invent it yourself. It doesn't even care what content that displays, cat videos or whatever.
Yeah, but I think that the way that the analysis has to unfold is first you ask, is this law burdening our speech? I think we agree that the law is burdening our speech.
Obviously.
Then you have to look at whether the law itself is
narrowly tailored.
somehow content-based, not just what their motivation.
Oh, never. Okay. Is content-based. Well, this goes to the tailoring of it, right? Like, what are they trying to ban exactly? Because it has to be a very precise, like surgically targeted law. It can't be a blanket huge law.
Are, but whether the law is content-based, and here the trigger for this law, the one thing that gets it going is if you operate a social media platform that has user-generated content, unless that content takes the form of a product, travel, or business review.
So this is a strange carve out from that law, because if there were security concerns here, why would you carve out things that do like travel reviews, right? So these are companies that can't be attacked. There is no cause of action on the behalf of the federal government because of this law, and the carve out is for the term covered company does not include an entity that operates a website, desktop application, mobile application, or augmented or immersive technology application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. But why? I don't know why this carve-out exists. I'm not actually sure. I don't know what the debate was in Congress for it. But this is also something that's brought up in their request to, in the request for the writ for certiorari for the Supreme Court to hear this case as well, is when they say, why do you have a carve-out for this? It doesn't make any sense.
Then within that universe of content, it says there's one speaker we're particularly concerned about, and we're going to hammer home on that one speaker. And then just to make the rubble bounce, they come in and tell us that one of the reasons they're targeting that speaker is because they're worried about the future content on that platform, that it could in the future somehow be critical of the United States or undermine democracy, to pull examples from the government's brief. So I think there's no way to get around the fact that this is a content-based speech restriction, and you do have to go directly to what their interests are. Now, their principal interest is...
I think I'm a little bit surprised by one of the answers that you gave to Justice Barrett. Is
this Kagan speaking? I don't know their fucking voices. That was I wanted to hear that line of questioning more. Fuck. Because this is probably the weakest or strongest, or this is probably one of the big points I would imagine of deliberation here is like, is this a target on TikTok's speech like in this way, or I feel like this is an important thing to hammer home, but whatever.
Understood that TikTok's essential complaint here is that they wouldn't be able to use the algorithm that ByteDance has invented, and that they want to use the algorithm that ByteDance has invented.
100%. And if I was unclear on that, Your Honor, I apologize. That is
okay, because I think what Justice Barrett was saying to you is like, what's the problem here? Because ByteDance is a foreign company. Or maybe this isn't what Justice Barrett says, it's just what I say. ByteDance is a foreign company, and you started off with Justice Alito saying, well, we would be making a different argument, and of course that's true. I mean, I would think that Alliance for Open Society makes it pretty clear that you have to be making a different argument with respect to a foreign state or a foreign company. So let's say that they don't have First Amendment rights. The only First Amendment rights lie in TikTok, which does have First Amendment rights. I guess my question is, how are those First Amendment rights really being implicated here? This statute says the foreign company has to divest. Whether or not that's feasible, however long it takes, TikTok still has the ability to use whatever algorithm it wants.
Does TikTok have so let's say that they force the divestment. Can't TikTok simply continue to use ByteDance's algorithm? The answer would be no, because it's ByteDance. Now you have to cut ties with that company. You might not have access to what they would license you anymore, no? You're burdening the speech. Maybe now TikTok has to pay some huge sum of money, or maybe ByteDance just doesn't license that algorithm to them or sell that to them. So this is hugely burdensome. So you could do this. You could use the algorithm, but this is burdensome. You have to go through more steps to do it. So whatever law is making this happen has to survive a strict scrutiny, I would imagine.
Doesn't it?
No, Your Honor. And their rights are implicated at a most basic level. In 10 days, TikTok wants to speak. In 10 days, because this law was passed, TikTok cannot speak unless ByteDance executes a qualified divestiture.
Correct.
That's not just ByteDance's choice. That is a condition
I
that's
realize
imposed
that
by law.
it definitely has effects on TikTok if
Not just an effect, it's burdensome, right?
ByteDance acts in the way that you are assuming it will act. So this is not to say that the First Amendment isn't involved, because TikTok is going to suffer some pretty severe incidental effects.
Yes.
But they are incidental, aren't they? Because the statute only says to this foreign company, divest or else, and leaves TikTok with the ability to do what every other actor in the United States can do, which is go find the best available algorithm.
That's not true, though, because it's only targeting companies that might have owners that have at least a 20% stake in your company from other adversarial countries. So, like, let's say that let's say you had Jew Talk instead of TikTok. Jew Talk wouldn't be burdened in the same way. Right? I think that burdensome stuff that only targets like a particular thing, suspect would be for strict scrutiny, right? You need a very, very, very compelling argument to do this. I don't think this would impact everybody equally. That's obviously the case, right? This isn't happening. Like X and Meta and Google are not having this conversation right now, right? Mark Zuckerberg, new podcasters with Joe Rogan is wild. He basically says the Biden government put mad pressure on to take down basic criticism about vaccine side effects. Let us see you watch. Yeah, we might watch it later. We'll see.
I very much disagree that the effects are incidental, because the way that this law works is it is only triggered if somebody is engaging in speech based on their content. User-generated content, except for business product and travel reviews.
That's true,
it
too.
then singles out a single speaker, and you have the concession for the government that one of the reasons they've singled out that speaker.
A lot of emphasis on the idea of just like, I think what you're basically saying is that all speaker-based restrictions generate strict scrutiny. I'm not sure that we've ever said anything like that. Let's put aside the
that speaker-based restrictions require strict scrutiny. We've never said that. Well,
anything like restrictions. I think what you're basically saying is that all speaker-based restrictions generate strict scrutiny. I'm not sure that we've ever said anything like that.
Oh, that's true. Because if the speaker has to do with like a non-suspect class, that wouldn't necessarily trigger strict scrutiny. That is true. Now, I'm sure he'll argue that maybe because it's based in another country, there's like a nationalistic or there's a racial aspect to it, I think, which is more in line with that. But, wow, Felix, thanks for your sober.
Let's put aside your argument that this is facially content-based. It seems to me that your stronger argument, or at least the one that most interested me, was this argument of, look, if the government is doing something specifically for the purpose of changing the content that people see.
Destiny, but she is saying that that is incidental, not a burden imposed by the law, but a burden imposed by the economic landscape. All companies are such that they could not be owned in the way TikTok is owned now. Divestment is thus necessary in TikTok's case, but that any company could likewise contract with some other company to license an algorithm, the speech. Okay.
For the purpose of changing the content that people see, that has to be subject to strict scrutiny. But I don't see that for the purpose of changing the content that people see. That has to be subject to strict scrutiny. But I don't see that as affecting TikTok as opposed to as affecting ByteDance.
Well, I very much do see it as affecting TikTok, because they choose this algorithm because it reflects the mix of content. The government's fear is that China could come in and pressure TikTok through ByteDance to TikTok to alter that mix of content to make it too pro-Chinese or too anti-American. That is very much directly a content-based charge straight at TikTok. The other point I would like to...
I hear you that it might very well have that effect. I guess what I'm suggesting is that the law is only targeted at this foreign corporation which doesn't have First Amendment rights. Whatever effect it has, it has. You know, maybe ByteDance will figure out a way to like put this on open source, and then TikTok will be able to use the app.
Oh, okay. I understand more what the chatter said and what she means by incidental. Is this law is truly just targeting, the law is targeting ByteDance, which is the foreign owner, but damage is done to TikTok are just incidental. It just happens to be this way because of that foreign owner. But so the foreign owner is really who's being implicated here, and then any damage to TikTok is just incidental.
So, Your Honor, if I could take that on directly, because I think TikTok has First Amendment rights to the extent ByteDance is speaking in the United States.
Oh, so I understand. So the real First Amendment challenge, because you're challenging their First Amendment challenge, is that TikTok's right to speak or engage in whatever algorithmic thing they want, that's not being implicated. You're just, what's happening, the reason why the algorithm itself isn't being attacked, it's the person that you're buying it from that's being attacked. And that's not a First Amendment challenge. And that wouldn't demand a strict scrutiny analysis. That might not even be intermediate. That might just be rational basis. That makes more sense. This would be like me saying, so now the analogy would be like me saying, let's say that I stream every single day and I get my microphone and my ability to publish online from Russia. And let's say the United States government sanctions Russia for some bullshit. And I'm challenging the US government. I'm saying, well, hold on, you're going to sanction Russia? You have to provide a very, very, very compelling argument to do that, because my First Amendment right is implicated, because now I can't get my stuff from Russia anymore. That's not a First Amendment violation on my part. That's incidental harm to me, but it's not directly implicating me. Yeah, that's a really strong argument, I think. That actually might have changed my opinion on this, I think. But we'll see. I don't know. Maybe this guy will argue his way out of it. Why did I think this was a good argument before? Because TikTok is being uniquely harmed here. But they're not. They're being incidentally harmed because of the targeting of ByteDance. He's arguing that it's because of the content. Oh, well, okay. But the counter argument is, well, hold on. You're not just broadly targeting ByteDance. You're targeting ByteDance because of my First Amendment exercise, because you're literally carving out like other businesses, but it's because I'm engaged in freedom of speech. Your interest is in curtailing my freedom of speech. You happen to be targeting ByteDance, but I'm the actual target. Because if I didn't exist as a company, this law wouldn't exist, right? There would be no law targeting this type of behavior, because ByteDance would just be doing things in other countries. I think is the counter argument. Ooh, that's actually a hard one. I don't know. Wait, never mind. I'm back. I'm back with TikTok, I think. Why are you targeting ByteDance? You're targeting ByteDance because of my activity in the US, not because of... Never mind. I'm back. I think I'm back on TikTok's side, but maybe we'll see. Okay, let's go. Let's see. I don't know.
It, I believe, has First Amendment rights
hold on.
directly, because I think TikTok has First Amendment rights to the extent ByteDance is speaking in the United States. It, I believe, has First Amendment rights. If you conclude that neither has First Amendment rights, then surely the creators have First Amendment rights. But if you take a step back, what their position is that none of these entities, this is the universe of entities affected by this law, none of these entities have the authority to assert First Amendment rights, which means that the government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat or won't disseminate the speech I want, and that would get no First Amendment scrutiny by anybody. That cannot possibly be the case. The government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat or won't disseminate the speech I want, and that would get no First Amendment scrutiny by anybody. That cannot possibly be the case. Yet,
why would they? What part of this law gives them the ability to say that? Because it would have to be foreign owned, right? There has to be that 20% foreign ownership in order to be a covered company, right? It has to do all 4 of these things. Permits a user to do this bullshit, basically be a social media company, has more than 1 million monthly active users, enables 1 or more users to generate or distribute content that can be viewed by other users. So these are like social media, and then enables 1 or more users to be generated. And then it has to be controlled by a foreign adversary. It couldn't just be that it's Republican and we don't like them, right? I think. I'm going to go back to the start of this answer.
None of these entities have the authority to assert First Amendment rights, which means that the government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat or won't disseminate the speech I want, and that would get no First Amendment scrutiny by anybody.
Oh, he's not even saying per this law. He's just saying in general. If we were to say that these companies have no First Amendment rights, then they could literally be shut down for any fucking reason. Like the government could say, okay, he's not even referencing, he's not saying with respect to this law, he's just saying in general, if we're going to say that there's no First Amendment rights here, then this opens the door for all sorts of speech restrictions, right? Okay.
That cannot possibly be the case, yet that is the effect of their position. The last point I'd like to emphasize, though, is this law, like the Playboy case, like the Hobby Lobby case, has built within it a less restrictive alternative, which is the general provision, by definition designed to protect against the very harm the government is identifying. Suppose New York State passes an asbestos abatement law. They say these types of buildings have to abate asbestos. In addition, New York Times, you have to abate asbestos in your building, and they say there are 2 reasons for this. 1, we want to abate asbestos. 2, we hate the New York Times editorial page. Surely, at the very least, what you're going to say is you can't target the New York Times directly. What you can do is throw them into the general process.
Thank you,
we think that's the minimum that should be done here.
Thank you, Counsel. We've been talking about connection between the regulation of TikTok and the burden on expressive conduct. And your basic position is that interfering with the ownership of TikTok constitutes a direct regulation of the expressive conduct of other people. What is your best example in our precedent of a situation where a regulation of corporate structure or something else has been treated as a direct regulation of expressive conduct?
The regulation of a corporate structure as
So one of the laws that the government wants to make here is this is just like a structuring of your company provision, basically, that's being enforced with private cause of action from the government, right? We're going to sue you if the structure is incorrect. So Roberts is asking, can you think of another example? Because right, common law tradition, whatever else, like it's important to have cases that have been rolled on that are similar to your case, because then you can point to, well, in our legal tradition, look, this has failed here, or it succeeded here or here. So Roberts is asking, is there any other time where the regulation of corporate structure has required strict scrutiny because it implicates a First Amendment right, just because of how corporations are structured or some corporate structure like that? That's a question that Roberts is asking here.
Of expressive conduct.
The regulation of a corporate structure as Your Honor, I don't have a case at my fingertips. I can consult.
Well, I don't have one at my fingertips or any other
rebuttal, but I think it's quite clear, though, that if you're saying to a company, you have to stop talking unless somebody else does something, and that's imposed by the force of law, it directly affects that company's speech.
Well, it's again, I don't.
You have to stop talking unless somebody does something else. Oof, this is like really hairy territory. Because the civil penalties would be imposed on the TikTok company. That's true. They're not just imposed on ByteDance, the owner. They'd be imposed on TikTok as well. And you're saying that TikTok's speech is limited based upon the actions that ByteDance takes. So that burden exists. I don't know. Oof, all right.
I don't know if it's directly affecting the company's speech or the speech of third parties, and I'm not.
Yeah, and then the question, is it direct implication or is it incidental or whatever, right? Maybe? Yeah, I don't know.
Not sure what, where your emphasis is. But again, I'm not sure there's another case where we've said that regulating a company others' expression should be treated as direct imposition on their speech in terms of the standard of review, for example, when it's based on derivative regulation of corporate structure of somebody else.
Well, they would only be imposed on TikTok given the condition they don't divest from the foreign company. So you can't divest from your owners, my friend. The owners divest you. That's like saying you know, I'm owned by Google, but actually I declare I'm divesting from Google. You're divesting from Google? How much? No, I'm divesting their ownership from me. No, excuse me. Google has to divest from you. They own you. You can't just say I'm no longer owned by them, right? The divestment works one way.
Your Honor, I think that I would concede that this is a pretty unprecedented case.
Yeah.
I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that...
Why can't you just be bought out? People are offering to buy out the company? What do you mean? Because you can't just buy shit from... You have to force another company to sell. And right now, nobody's being forced. It's just a choice, right? You can't force... Yeah. So it could be the case that ByteDance says, oh, well, this is untenable. We're just going to shut TikTok down. And then they leave. And TikTok has no recourse there. They can't say, well, we don't want to shut down. We want to be sold. They just say, well, we're shutting them down, and then leave.
If a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based, viewpoint-based reasons, and in particular on this record, because the speaker that is ultimately being shut down, they don't like the speech of that particular platform, that's a real problem.
So it may be a real problem remaining.
So just to understand the whole argument chain here, okay. Jesus. So the argument is from the... Wait, not... What do you call them? Not the plaintiffs. From the petitioners? Well, no, they would be the plaintiffs here. Okay, so from the plaintiffs, the argument is the government is trying to... the government has created a law that is forcing a U.S. entity whom enjoys First Amendment protections to potentially cease operations where freedom of speech is implicated based on the actions of a third party who's implicated by said law only due to the government disliking the content or speech of the U.S. entity involved. I think this is the chain. I'm trying to think if I can simplify this more. I think this is basically the argument that that TikTok and ByteDance are going with, that the government is creating a law that's forcing a U.S. entity, in this case TikTok, who should enjoy First Amendment protections, which invokes ideally strict scrutiny review, to potentially cease operations. So they're going to stop doing a thing, which is very clearly like a freedom of speech thing, right? Based on the actions of a third party, which is ByteDance, who's being forced to comply with this law from Congress, who's implicated by said law only due to the government disliking the content, speech of the U.S. entity involved. Okay, this is the full argument. And I think every single one of these things has to stand on their own, or they all have to stand, and if any falls, then it's okay. So for instance, what are the 1, 2, 3s of this? Okay. The government has created a law that is forcing a U.S. entity hold on, let me just, so we have, okay. The things that TikTok and ByteDance have to argue successfully here is that TikTok's speech is implicated, and their speech being access to control of the algorithm. The law passed by the government is implicating content/freedom of speech. So this law is not just a national protection law or whatever. It's a law that is directly implicating the freedom of speech. And that, and I think they might have to argue also that, that TikTok's survival depends on a foreign party's response to said law. ByteDance/China's response to the law/lawsuit, I think, right? I think these are the three things that have to, TikTok has to get all three of these things down in order to win their case here, basically, right? I think. Why not Congress instead of the government? When you're talking about lawsuits, you're always talking about the government because Congress has nothing to do with lawsuits. Fuck, there's a fancy Latin bullshit expression for this, but Congress can't do lawsuits. It's the Congress. All they can do is pass laws. The government is always the executive branch because they're the ones that enforce laws and bring lawsuits. So when we talk about the Department of Justice, or we talk about the Department of Justice or the government suing somebody, it's always the executive branch. It's always the DOJ. Okay, sorry. All right.
Speech of that particular platform, that's a real problem.
It's based on derivative regulation of corporate structure of somebody else.
Well, Your Honor, I think that it's, I would concede that this is a pretty unprecedented case. I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that if a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based, viewpoint-based reasons, and in particular on this record because the speaker that is
let me just write
speech platforms. I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that if a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based, viewpoint-based reasons, and in particular on this record because the speaker that is ultimately being shut down, they don't like the speech of that particular platform, that's a real problem.
So it may be a real problem or may not, but I just...
Good one. Yeah, okay. The law imposes a direct regulation on a third party. This regulation shuts down someone else's speech, and the law is passed for viewpoint-based reasons. Yes, these are the three. Okay. So the law imposes a direct regulation on a third party. That's the TikTok survival depends on the foreign party's response to said lawsuit, correct? This regulation shuts down somebody else's speech. The TikTok speech is the speech being access to / control of the algorithm, and their speech is shut down if they lose access to this. That's what this means, right? And then the law is passed for viewpoint-based reasons. The law is passed by the government is implicating content/freedom of speech. So because they're targeting like social media companies or whatever, it's clearly implicating a type of speech here. It's not just on all companies. It's targeting like a particular type of speech, right? So, okay, yeah. Okay. Sorry, Jason. All right.
I'm wondering if there's any precedent where we have that same connection and that it affects the standard of review, for example. You would treat it as a direct restriction on expression. Even the only thing the law does is say, in this case, somebody other than the Chinese government has to own.
So we don't have any direct precedent along the lines that you're citing, but we do have precedents. We have cases like ACARA. And what ACARA says is if the law is totally speech neutral, then that's one thing. We have cases like O'Brien, which say if the law doesn't care about speech but happens to draw in speech, that's another thing. Both of those cases make clear, however, is that when the law is concerned with the content of the speech when the justification is based on the content of the speech. That's cases like Reed 2. Then you do trigger strict scrutiny.
So then I think your argument comes down to, is this direct concern with speech, or is it concerned with the potential for Chinese interference with the level of interference indirectly? In other words, they're not coming back. The Chinese government, TikTok, doesn't care what the people are saying on TikTok. That's not the concern. The concern is that they are regulating a particular channel of communication. And I just wonder if there's any precedent for that type of thing. They're not saying we're going to restrict this content and that content, but not this. They're just saying we're going to be in a position where we can control what happens, whether it's based on expression, whether it's based on anything else.
So, Your Honor, I disagree. And I think if you take a step back and look at this record, I think it is quite clear that it is focused on both current and potential future content on TikTok Incorporated. Here, you don't have just an act that is based on speakers and speech. It's triggered by speech. It's focused on a single speaker, TikTok Incorporated.
Justice Thomas, anything further? Justice Alito?
What if Congress, if there were nothing in this act about content moderation or covert manipulation, what if it was just about preventing what Congress views?
Content moderation or covert manipulation. Was there anything in the act about that explicitly? Covert. I don't know what he's referring to there, but I don't know. This might be a dumb question, but why is precedent so important to ruling and judges more generally? Like, why do we lend so much credence to what people already thought? Because the U.S. it's complicated, but part of the U.S.'s historical tradition in law is rooted in the concept of common law, which means that we kind of look to prior rulings and judges to fill out exactly how we interpret a lot of the civil law or codified law that we have in the United States. So prior decisions that judges made in terms of how they might interpret a particular statute or apply a particular statute become incredibly important to future judges. It's just how the U.S., I think that's like part of a theory of common law, basically.
Viewed as an enormously powerful, popular application from gathering an arsenal of information about American citizens. And they said, this is the worst offender, and we're going to require divestiture by this offender.
That reminds me, is that one conservative lawyer that you argued with correct about common law? Did you look into it after the fact? I tried, so I thought this was a thing I could read a quick Westlaw thing on. Common law and civil law and the differences between the two are, there's a whole ass like fucking theory of both of these things. But common law, I think, implies a lot more that the United States doesn't do. So like, for instance, like the idea that like a judge himself could just basically say, I think this is what this thing is like. And the idea that we do have codified statutes, which I think is considered part of like a civil law system. But I think, ask somebody in law school. I don't know what they teach in law school. If they teach you that like, oh, America is a common law system, because we have aspects, I think, of both systems, I think. But I don't know if there's somebody who went to law school who can say that or whatever. I don't know what the answer is there.
Arsenal, popular application from gathering an arsenal of information about American citizens. And they said, this is the worst offender, and we're going to require divestiture by this offender. Would there be a First Amendment problem there? And if you think there would be, what would the level of scrutiny be?
Yeah. Yes, there would be a First Amendment problem if you had a law like this that was only focused on speakers, those who use user-generated content other than product, travel, or business.
Well, Congress concludes that this particular entity is the worst. This is the worst offender, and it happens to be an entity that is involved with speech.
If all you had, so I want to make sure I understand the hypothetical. The only provision you have is one that says this company has to shut down because of data security.
Right.
I would have a different set of arguments. I think it would still implicate the First Amendment, particularly where you have strong evidence that they were being targeted in part, at least because of their speakers and speech. Suppose Congress passed the law that you posited.
But you're changing the hypothetical by injecting congressional concern about the
Okay, well, I'll put that to the side.
So what would your argument be? It would be an equal protection argument?
No, I'd still be saying that a ACARA itself makes clear that where a law disproportionately burdens just a speaker, we have to subject that to scrutiny to suss it out, to suss out whether the asserted interest is the actual interest. There, the asserted interest is in data security. I think I would have...
When he says we have to suss out if the asserted interest is the actual interest, like, it could be that maybe I go to a city and I see that all the white people work an engineering job and all the black people work an NBA job. Okay, make it however you want, right? And I say like, oh, I'm going to pass a law that says all black people are slaves again. Well, the court would look at that and they would say, well, we're implicating fundamental rights. You can't do this ever. Well, that wouldn't even survive Russian. But you make a law saying like all black people have to, you know, say the Pledge of Allegiance 15 times a day while they're walking up and down the street, or else a cop can kill you. Okay, right? That would be like, well, no, you can't do that. Obviously, you can't target black people here. You're implicating fundamental rights. You're implicating class of people. It's not good. Sus class, not good, right? But what if you said, okay, well, okay, true. We're not going to target all black people. We're just going to target all NBA players. Get it? Look at how cute that is, right? I think this is the second prong of the intermediate scrutiny argument. It's like, well, hold on. Are the means by which you're targeting somebody substantially without that interest? Wait, that's not true. Hold on, wait. This might even be part of the strict scrutiny thing. Wait. This might be under the least restrictive means part or something. No, wait, fuck. I feel like I read a thing that like you have to show that the thing that you've done is not like also like tailored to something that would implicate another class or something, or implicate like a thing that would cause an elevated standard of review. Fuck, I don't remember what this would implicate. I know I read this somewhere recently. You can't like target somebody using like another thing. You can't be like clever. Like in effect, you end up targeting a thing that would cause a heightened review. I think that heightened standard would come into effect. I know this came up in although I don't know if this became a federal case or not, that North Carolina voter ID shot, but.
A couple of arguments under whatever form of scrutiny you wanted to apply, whether it is strict scrutiny or intermediate scrutiny in that context. I would say first that law is dramatically under-inclusive because it categorically exempts e-commerce apps that this record shows have comparable ties to China.
You say, I don't want to prolong this too much. You say this is not like ACARA, I think primarily because you say that the divestiture requires the new company to cease using the algorithm, right?
No, I think it's not like ACARA for a much more fundamental sense. ACARA involved a totally speech-neutral law. It didn't go after speakers at all. If you had a law in ACARA that said we're going to prohibit prostitution in bookstores only, then I think that ACARA would have come out differently. There would have at least been, some kind of intermediate scrutiny, potentially strict. That's the law that I think is your hypothetical.
Walk away from the hypothetical that I posed for the purpose of narrowing in on what your argument is. I understood you to say that that would not be a solution to the problem, because one of Congress's motivations was based on the content of TikTok. Am I wrong in that? Did I read your argument incorrectly?
Well, I think that I want to make sure I understand what you're saying. I certainly think that because one of the motivations was content, that is an enormously important fact. I was trying to answer your hypothetical where we were trying to take that out of the mix. And the reason why ACARA is different is because ACARA didn't just simply say no prostitution in bookstores. That's what your hypothetical effectively says. It says no data security problems in speakers or in this particular speaker. And I think that would trigger, at the very least, intermediate scrutiny.
All right, thank you.
Justice Sotomayor? That goes to my question. which is the Chief Justice asked you whether or not we've ever had a case where pure ownership was at issue and not speech. And I don't think we've had one like that. You're right. But I don't think that the question gets to the essence of your argument, is it? The essence of your argument is you're being asked to divest because of speech, correct?
Correct.
Right. One of the three prongs that he brought up is the laws passed for like viewpoint-based reasons, speech-based reasons.
Right. So if I get past that, if I go to Justice.
How come we can hear them but not see them? Do they not let cameras in? No, they train a lot. I think ventriloquism is one of the big requirements for being a Supreme Court justice. This is actually them speaking. Their lips just don't move.
Correct.
All right. So if I get past that, if I go to Justice Alito's point, which is I don't think it's just about speech, it's about data control. If it's about data control, and assume, for the sake of argument, that I believe intermediate scrutiny applies to the data control provision, then your arguments would be different, wouldn't they? They would be under inclusiveness, they would be other arguments, correct?
Well, I think they'd be very similar because I think the nature of our arguments work just as well under intermediate and strict scrutiny. If I could unpack that a little.
No, I'm not going to,
Sure.
because we're going to run out of time, because we're going to need to figure out what intermediate scrutiny means. But I'm not sure it means what you do, which is I don't think any of our cases have ever suggested that we have to use the least restricted means under intermediate scrutiny. In fact, our cases have said we have to use a reasonable means.
And if I could respond to that point specifically, I completely agree it's not a least restrictive means alternative, Your Honor. But you do have to at least consider alternatives. Here, if the concern, let's take the data security concern, which you put your finger on.
I know you want to keep going on, but I can't let you, because I can't monopolize the argument, okay? But let me just get to the bottom of that, all right? You seem to suggest that Congress has to actually look at all of the alternatives and say no. I don't think we have a case that says that.
I am not
If from the record it's clear that alternatives won't be adequate for whatever set of reasons, isn't that enough?
If the record were clear on that.
Is this a partisan issue or is this a rare case of Democrats and Republicans both wanting it banned? I think initially they did. But my guess is going to be that Donald Trump doesn't want TikTok banned, but I don't know if he said anything too recent about it. I know a little bit ago he kind of said this, but Trump is retarded. But Trump was like, oh, I thought TikTok was for me. I don't think we should ban that. So I don't know I think that as long as the content on TikTok seems to be supportive of Donald Trump, I think he'd probably be okay with keeping it. But I don't know if he's made anything more recent about that. However, a lot of the billionaire donor class, the financial interests behind Trump, would definitely want TikTok banned, which could also be part of why Zuckerberg and Elon are all sucking Donald Trump now. Because if TikTok gets banned, it's really good for Twitter, because now it's just a whole new social media platform that people move off of. It's really good for Instagram, because if I had to guess, I don't know if anybody has marketed on this, Instagram Reels are probably the biggest competitor to TikTok. And TikTok-like stories or whatever, be my guess. So if you knock out TikTok, then Instagram Reels are in a real good place. Also, didn't Facebook also acquire Snapchat? Is Snapchat owned by Facebook? God, it's so gross. I just said they're gross. That's not even true. Never mind. Oh, no. They own, I'm mixing them up with is it WhatsApp or what? There's another thing that was acquired by Facebook. What am I thinking of? WhatsApp, I think. Yeah. WhatsApp doesn't implicate it all here, but yeah. In a way, this is the protectionism that the big domestic companies want, because getting rid of TikTok or making it so that TikTok is now acquirable somehow by, because there's no way that TikTok runs profitably, would be my guess. I don't know. This seems to be the case. So now TikTok is just going to be up for grabs between whichever one of the 4 huge companies in the U.S. wants to buy it or something. Like, that's just such a great thing for domestic companies. Whew.
That might be enough.
Now I take
here
that.
on
Now
the
let me
key,
go to the next question and the last.
if I could, Your Honor, just one sentence. If on the key less restrictive alternatives, they had actually considered them and said what you suggested, this would be a different case. But our point is that on the key, most obvious, less restrictive alternatives, a law, for example, that simply prohibits TikTok Incorporated from sharing any sensitive user data with ByteDance or anyone else, there's nothing in the record that suggests they even considered it. And that's why it would fail under even intermediate scrutiny.
We have a different problem, which is that the record shows that there is no sharing that could happen that wouldn't put the data at security. But we can go past that.
That's incorrect, actually.
No, because the NSA doesn't. What's very
I'm not
clear-
talking about the NSA.
or even anything else. But putting that aside, one last question. Assuming that the covert manipulation issue is one, I think that what remains is, to the Chief's question and Justice Alito's questions, if the covert manipulation is a concern, then the question becomes what kind of burden does it put on TikTok USA? And I think your point is that that requires strict scrutiny because it doesn't permit them to speak to the Chinese government through the algorithm and promote whatever speech it wants to promote through the algorithm, correct?
It doesn't prohibit.
Wait, does she really think it's called algorithm? It sounds like she said that twice. Oh, no.
Promote whatever speech it wants to promote through the algorithm, correct?
It doesn't permit them to speak to the American public through the algorithm.
Right.
And promote whatever type of speech they want to promote on the algorithm. And I also think that this covert manipulation is a little bit odd. They're not concerned just with covertness. If all you were concerned
I'm going to ask.
Would you personally be happy about a TikTok ban? Like personally, like absent any legal considerations? I don't know, probably, I guess. I don't know how successful, it's one less platform I'd have to worry about expanding to, so.
Ask she about that. How do you disentangle the two things?
Thank you, Your Honor.
Legally, I don't know. This is an interesting case. I'm generally a free speech person, though, so I think you need to make pretty compelling arguments to be opposed to freedom of speech stuff, obviously. But I don't know. I'm not sure.
Justice Kate? Justice Gorsuch? Justice Kavanaugh?
Just on the data collection interest, I think Congress and the President were concerned that China was accessing information about millions of Americans, tens of millions of Americans, including teenagers, people in their 20s, that they would use that information over time to develop spies, to turn people, to blackmail people.
But actually, I'm curious. You say one less platform. I know you're kind of memeing, but without legal point, isn't this exactly what you support? Less concentration into bigger companies? What are you talking about? If TikTok gets banned, it's literally more concentration into bigger companies.
Who a generation from now will be working in the FBI or the CIA or in the State Department.
Not banning it. Oh, sure. Yeah, but I mean, if they're literally working with China or some bullshit, I don't know.
Is that not a realistic assessment by Congress and the President of the risks here?
Well, Your Honor, I'm not disputing the risks. I'm disputing the means that they have chosen. One way, the most direct way to address that, all of this user data sits on data servers in Virginia controlled by Oracle. I'm not talking about the National Security Agreement. What I'm talking about is a law that simply says to TikTok Incorporated and its U.S. employees, you cannot share that user data with anybody. You can't give it to ByteDance. You can't give it to China. You can't give it to Google. You can't give it to Amazon. You cannot give it to anybody under threat of massive penalties. They never even considered that most obvious alternative. And so whether you apply intermediate scrutiny or strict scrutiny, it's not a least restrictive means test, but you got to at least consider the most obvious alternative.
So you acknowledge the risk that Congress and the President were concerned about. You're just saying the means they chose to address that risk were incorrect,
So
not permissible.
I certainly acknowledge the risk, but I think there are lots of reasons, not just the one I just gave, but there are lots of reasons why that risk still can't justify the law. When it sits alongside of the impermissible covert manipulation risk, I think it falls under Mount Healthy. It's no different if they came in and said, we passed this law, one for data security.
I understand that, but just on the data collection, that seems like a huge concern for the future of the country.
And Your Honor, again, it is a concern, two responses. First, it is a concern that can be addressed directly. The reason why there's no evidence in this record about whether that kind of direct prohibition on TikTok Incorporated from sharing sensitive user data with anybody, including ByteDance, the reason why the record is devoid of any evidence of that is because Congress never considered the other side of the balance. And that's the minimum that Congress has to do under the First Amendment. It's got to at least consider the consequences of shutting down a speech platform used by 170 million Americans against the benefits of an alternative, like simply saying to TikTok's employees, you're essentially going to get massive fines, potentially jail sentences, if you share any of that sensitive user data with anybody. Not TikTok, not ByteDance, not China, not anybody else in the world. Yet there's nothing in this record that suggests they even considered that alternative.
What happens after January 19th if you lose this case? Can you just spell that out?
At least as I understand it,
TikTok would probably cease to function, and then it would probably cease to exist, right?
we go dark.
Yeah.
Essentially, the platform shuts down.
Unless there's a divestiture.
Unless there's a divestiture, unless...
Not just a divestiture, though. It has to be a divestiture, then it has to be a massive coordinated effort. It probably won't be able to be completed in time, so they would have to ask for an injunction against like the penalties, and they would have to, like, yeah.
President Trump exercises his authority to extend it by night, but he can't do that on January 19th. On January 19th, we still have President Biden, and on January 19th, as I understand it, we shut down. It is possible that come January 20th, 21st, 22nd, we might be in a different world. Again, that's one of the reasons why I think it makes perfect sense to issue a preliminary injunction here. And
because the injury would be not irreparable, but it would be a significant injury. Yeah.
Simply buy everybody a little breathing space. This is an enormously...
What do you mean by shut down, too? Can you just spell that out?
What would they even be allowed to do? I don't even know if they'd be allowed to serve a web page saying you can't access anything right now. Well, I guess they would, because then they'd no longer be a social media company or something, right? Let me use this real quick. 1 second. Oh, Jesus.
So
if you
the app is not available in the app stores. That's at a minimum. But in addition, what the act says is that all of the other types of service.
Everybody that works with TikTok needs to immediately stop working with TikTok. Oh, that could implicate so many things. So like if you log in using an OAuth, you might be disallowed from working with TikTok. So you can't even log into your account if you use your email address from Google or whatever else. Like all of these companies have to cut contact.
Providers can't provide service either. Now, there's enormous consequences for violating that for the service providers. So essentially, what they're going to say is that, I think we're not going to be providing the services necessary to have you see it. So it's essentially going to stop operating. I think that's the consequence of this law, which again is why a short reprieve here would make all the sense in the world. It's an enormously consequential decision, and I think all would benefit if it weren't necessary.
Thank you.
Justice Barrett?
So I just want to, it's kind of following up on Justice Kavanaugh's questions. Let's say I agree with you that some level of scrutiny applies, and I'm trying to figure out which level of scrutiny applies, and I'm trying to figure out if there's content discrimination. And let me ask you a different question than I did before about the algorithm. I mean, you keep saying shut down. The law doesn't say TikTok has to shut down. It says ByteDance has to divest. If ByteDance divested TikTok, we wouldn't be here, right? If ByteDance was willing to let you go and willing to let you take the source code with you, that would be fine, right? We would not be here.
Well, Your Honor, if ByteDance divested, then the law wouldn't fall on TikTok.
Because they would no longer be one of the defined parties or whatever. What do you call it? They would no longer be what's the name of it? What do you call it? They wouldn't be a covered company because they wouldn't be a foreign adversary controlled application.
But the law, not ByteDance.
But that's because of ByteDance's choice, right? I mean, this is like Justice Kagan's point. I mean, I'm trying to figure out how we account for the reality of third-party choices and the choices of third parties that the whole reason for the law being passed in the first place.
Yeah, Your Honor, I still don't, I think that the way the analysis works is step one, is there a First Amendment violation?
Right.
Oh my God, I'm so fucking stupid. I hate my life. I'm sorry. Why do I even have a schedule? I put him on the schedule, and I even put it in the stream schedule. No one in chat says anything. Fuck you guys. You guys don't even use the schedule. You don't look at the schedule. You don't want a schedule. You want me not doing the schedule. You need me. Fuck you guys. Fuck, I thought he would have responded to my last email. I think I was relying on that. Dumb. Well, let's see if he responds. Good luck.
Right.
Step two, you get to the question that we're grappling with. What standard of scrutiny do you apply? Typically, what you do is you ask, is this law content-based? Is it content-based based on its face? Is it content-based in its decision? Here, we know it's content-based on its face because it says what it says. We know it's content-based in its motivation because the government concedes it's content-based in its motivation.
Well, that's not quite what I'm asking. I mean, let's see, that's the dispute between you and the government. Is it content-based if it's about divestiture and not about telling TikTok what content it can display on the platform?
And I think it has to be because I think that really goes to the first question. Does the burden fall on the speaker? If the burden falls on the speaker, that triggers the speaker's First Amendment rights. But the law is, in fact, content-based, whether it comes in the form of a divestiture or something else. When the law specifically says it's content-based, we're worried about the content on the platform. And when the government tells you that one of the things that we're worried about is TikTok, not ByteDance, but TikTok Incorporated and TikTok in the United States will, absent the divestiture, have a mix of content that we find objectionable.
Is Section 230 just null and void here, or how is this factoring in? Am I retarded? You'd be applying that at a different level. It's not relevant to this, I don't think, but we'll see. Maybe it'll get brought up.
They will mix around their videos in a way that is too pro-Chinese or too anti-American, and that is TikTok, the platform.
Let me just ask you one last question. Why is it impossible to divest in the 270 days, even assuming that the Chinese government hadn't said you couldn't?
Sure, and this is the exchange I was having with Justice Gorsuch. There are two basic reasons.
Is there a constitutional limit that says that oral arguments are only an hour per party or something? Is that a thing, or is it just a rule they have? Is that why they're trying to go over time? Or?
The first is that the underlying source code, that's the source code that comes in here and then has to be converted.
But that's what Justice Gorsuch said, just not ever. So it's not really that you can't do it within the time frame. It's that you really couldn't ever divest because you never are going to get the source code.
Well, let me unpack that a little bit. No, it's that with the underlying source code, it takes a team of engineers to update and maintain that. It would take us many years to reconstruct a brand new team of engineers to do that with respect to the source code. With respect to the sharing of content, that was the different reason. In theory, we could kind of send our salesmen around the world, go to Ireland, go to Finland, go to every country and say, look, you used to automatically get our content, but now you got to separately sign up for our platform.
Last point, let me make sure I understand what you're saying. It's not that you couldn't execute the disentanglement. You could say, we're independent. You just can't recreate TikTok in any kind of way.
Well, I think that any new TikTok would be a fundamentally different platform with different content, which is yet another reason why I think this is a content-based restriction that falls directly on TikTok Incorporated itself in our platform.
Justice Jackson?
So I guess I'm back to some of the questions that Justice Barrett and Justice Kagan asked about the sort of threshold issue that you point out, which is there a burden on the speaker? I'm trying to understand what the burden is that you are articulating and whether it really isn't about association and not speech. You say you have...
This is arguably maybe the most important question. I'm saying that, but I don't know what the fuck do I know. That if there isn't a burden on the speech, if this is my guess as a non-lawyer dipshit, if it's an intermediate scrutiny or a rational basis, then they auto lose 1 trillion%. They're auto lost. I think the only chance that this has of winning is if they can argue for a strict scrutiny review, because that puts the highest burden on the government. I don't even know if they're going to win that, but that's probably the only path to victory, right? But in order for it to be a strict scrutiny review, they have to say that their speech is being attacked. And that's why a lot of this conversation is going back to, well, hold on. Is this really directly burdening your freedom of speech? Just because the company above you has to divest from you? Is it really directly implicating your right to freedom of speech just because of your relationship with another company? That's why they keep going back to this line of argumentation, I think, because it's pretty important. It's pretty important.
Have in your brief some cases that talk about American speakers being free to choose whether to affiliate with foreign organizations. And the colloquy you had with Justice Kagan made me think that what you're really complaining about is the inability to associate with ByteDance and its algorithm. That it's not really about, if TikTok came up with its own algorithm or bought an algorithm from some other company or devised it or whatever, this law would have nothing to do with them from your perspective. But the problem I think you're articulating, and this is, I'm seeking your clarification.
Sure.
The problem I think you're articulating is that you want to use ByteDance's algorithm and therefore associate with ByteDance, and Congress has prohibited that by requiring divestiture.
Yes, but his argument has to be, this is what they're trying to argue, is that, sure, that's true, but the termination of our relationship is based on our speech. You're trying to make us divest because you don't like that there might be some speech that we give, because if it was all, you know, peachy about the United States, we wouldn't be here right now. It's because you don't like the Chinese propaganda that you're accusing us of spreading on this platform. You're implicating free speech by doing that. It's the argument that he's trying to make on this.
So isn't this really a right of association case under the First Amendment?
I think it's both, Your Honor. I do think that that is a component of it. We want to use the algorithm that we think reflects the best mix of content. That's the algorithm that reflects the best mix of content. What this law says is we can't do that unless ByteDance exercises a qualified divestiture. But I also think more directly what this law does is it says to TikTok Incorporated, if ByteDance doesn't exercise a qualified divestiture, you have to go mute. You cannot speak at all.
No, I don't think it says.
That's not at all what it's saying. I don't know why. I don't know if he just had a fucking stroke. That's the worst and dumbest argument. I don't know why he just said that. The argument is that they're only asking us to terminate our association with ByteDance because of our content, because of our viewpoint, because of our speech. I don't know why he just said that. Oof. I don't know. I have no idea why he just said that.
You have to go mute. You cannot speak at all.
No, I don't think it says that, though. I mean, if TikTok...
Because TikTok could just... No, hold on. No, I'm so sorry. Wait, no, that is kind of true. Well, there is one more part to it. They have to go mute if ByteDance doesn't divest. Or was she saying if they divest? Because if ByteDance doesn't divest, then TikTok has to shut down. There's nothing they can do. It's dependent on the actions of a third party, right?
Were to post-divestiture or whatever, pre-divestiture, come up with its own algorithm, right?
No, because ByteDance has to divest. ByteDance has to divest. TikTok can't make that decision unless there's some corporate thing that I don't understand, which is entirely possible. I've never divested a company before.
Then when the divestiture happened, it could still operate. It doesn't say TikTok, you can't speak.
I think that's theoretically correct, Your Honor, but I think that also underscores the content-based nature of the restriction.
No, but the fact that that's...
The content-based, this is the one that you're supposed to argue, yeah.
It's true, suggests that you're wrong about the statute being read as saying TikTok, you have to go mute. Because TikTok can continue to operate on its own algorithm, on its own terms, as long as it's not associated with ByteDance. So isn't this really just all about association?
But ByteDance could say, I don't think this is the key thing that the attorney should be focused on. I understand why Jackson is on this, because from that perspective, it's not really a freedom of speech or content thing, right?
Your Honor, I think it is partly about association, but I'm going to take another shot at explaining why it's not just about association.
Okay, well, let me just take you down the association path for a second, because if it is about the association of TikTok with ByteDance, then don't we have cases that seem to undermine your view that Congress can't do this? I mean, I thought we had cases about Congress prohibiting association with terrorist organizations.
Yeah, this is all easy to do, of course. I don't know why. Is freedom of association, is that even like a fucking thing in the United, or I don't even know what the fuck that means. That sounds like a sovereign citizen thing. What the fuck is freedom of association? I don't know what that means. I don't know why he would even bite at that argument at all. But there might be really good reasons, by the way. Maybe there's case law or some shit that I don't fucking know anything about. Maybe there are really good reasons for it, but...
prohibiting association with foreign adversaries. And so why doesn't this fall into that kind of group of our jurisprudence?
Well, at least as I understand all of those cases, they applied strict scrutiny. The material support statute most definitely applied.
First Amendment? Wait, what is... I don't have these memorized. Is there and your freedom to associate with foreign, or the freedom of association at all, or what? Where's the text? Why is it that when I go to the Wikipedia for this, shouldn't the text of the First Amendment literally be like the first section? Good. True. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging, meaning placing restrictions on, the freedom of speech or of the press or the right of the people peacefully to assemble and to petition the government for a redress of grievances. Where are we reading the right of free association, especially with foreign company? I don't think that's, unless we're saying to assemble? Are we talking like corporate? This just sounds like basically the people having the right to, I guess, like make their grievances with the government known as like a group or whatever. I don't. But maybe there's a way this could have been read into. Hold on. The First Amendment protects many activities such as blah, 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 blah. The right of expressive association is the focus of this set of essays. The court has also recognized a personal liberty interest in certain intimate human relationships. Intimate association is discussed at the end. Court acknowledges recognized constitutional right of association. I don't think it's sided with the companies. I don't believe this. Or even if it does, even if it implicates that, it wouldn't be the right of free association with foreign companies, no? Or maybe, I don't know. Don't care.
The material support statute most definitely applied.
And ultimately upheld the laws.
Hold on. Okay.
So fine.
But sure, and I think if we go down the strict scrutiny road here, I don't see that this law can possibly be satisfied under the interests that they assert here. But I do want to emphasize why this is also about TikTok speech. Even under your hypothetical, where theoretically they can say something differently than they are saying today, that in and of itself is a direct restriction on TikTok speech. They can't engage in the speech they want to engage in. They have to engage in a different kind of speech, the speech they don't want to engage in. That is a direct burden.
That feels like a really, really, really weak argument here. I don't understand why this is being presented. Maybe it's for reasons I don't get, but I don't know why. Because any sanction or anything restricting any foreign company would dictate some of your speech a little bit, but I don't know. I don't understand this.
On TikTok incorporated speech.
All right, I think I understand that argument. Let me ask you a question about your colloquy with Justice Kavanaugh. Did I understand you to concede that there is a compelling interest and that the problem is really tailoring? I mean, you said, I understand the risks. I don't hear you suggesting that the risks don't exist. So it sounds like we've gotten past, even if we're in strict scrutiny world, we've gotten past the compelling interest part of this.
No, Your Honor. What I was saying is that all you had standing alone were the data security. That would be a different case. Here, when you have the content manipulation sitting right alongside of the data security, that taints the data security rationale. If Congress came in and said, we're passing this law for two reasons. One, we really care about data security, and two, we hate the speech on TikTok. The data security wouldn't alone sustain that law under cases like Mount Pleasant.
I understand, but why you're equating we don't want foreign adversaries to be able to manipulate the content on this platform. You're equating that with we hate the content, and I'm just trying to understand why.
Because content manipulation is by definition a content-based distinction. Look, everybody manipulates content. There are lots of people who think CNN, Fox News, the Wall Street Journal, the New York Times are manipulating their content. That is core protected speech.
Yes.
That's why they put so much weight on this mere covertness.
Right, but that analysis is just about content-based versus content neutral, and therefore whether you apply strict scrutiny. I'm in the strict scrutiny world, okay? I'm assuming that you're right, that strict scrutiny applies, and now prong number one in that world is, does the government have a compelling interest? And so I'm trying to understand why the government's argument that we have data manipulation concerns, which I understood you in
he concedes point one, right? Prong one is, of course, the government has a compelling interest, but it doesn't satisfy prong two that the law is narrowly tailored enough, right? Isn't that the
colloquy with Justice Kavanaugh to say is a risk? And we are concerned, based on what Justice Gorsuch says when he's looking at the facts, that the government contends that there's this real problem with this foreign adversary doing manipulation in other places. Are you saying those are not compelling government interests?
I am 100% saying that content manipulation